Good afternoon. Good afternoon. It's December 2nd. I can't believe it. You can't believe it. We can't believe it. But here we are in December, back in court for the state of Florida versus Sarah Boone. If you watched the trial with me live here on the channel, then you are very familiar with this case. If you did not watch the trial with me and you are just tuning in, don't worry, I've got you. Sarah Boone was convicted of the second-degree murder of her boyfriend, George Torres, when she left him zipped in a suitcase and then recorded herself mocking and taunting him, amongst other things. She put on a defense of battered spouse syndrome. The jury did not find that credible and did not deliberate very long in convicting her of that second-degree murder. That defense opened the door for a lot of information we wouldn't have seen otherwise that did not paint Sarah Boone in a good light. And the danger with that is the judge has now seen those videos too. They were shocking and heartbreaking. And Sarah Boone recorded herself abusing and berating her victim. And what the problem is with that is her defense was always a long shot. But now the judge knows. The judge has now seen all those videos. The judge wouldn't have seen those videos otherwise. He might have heard about them from the prosecution, but it wouldn't be so visceral. Seeing it is different. Being told about it, hearing lawyers talk about it is different. So with that second-degree murder conviction, she is facing a minimum of 22 and a half years, a maximum of life, and that's an indeterminate life, which means she could be eligible for parole down the road. It is a second-degree murder. She is also facing a maximum of 15 years on the lesser-included manslaughter, but she won't be sentenced to both of them. They are included in one another. So the second-degree murder, that manslaughter is lesser included. So with that second-degree murder conviction, the minimum is 22 and a half years. The maximum is life. I imagine that this is a foregone conclusion that she will get life. The real questions here are who from the victim's family will speak. I'm sure there will be some, and possibly his children. Will Sarah Boone speak on her own behalf? She'll have the opportunity to. And what will the judge say? What will the judge say? So, with all of that, there is also a pending motion for new trial, and I'm seeing some in the chat. Max said the state's response is in. When I checked last night, no. When I checked this morning at like 2 a.m., it wasn't in yet. I'll tell you more about why I was up at 2 a.m. another time. Those of you that are members know. Miguelina mentioned the random beep. That was coming from the court feed. So that's not on my end. That was on the court feed. I muted the court feed. Court is not in session yet. I will go and grab the new trial. I'm going to roll the intro. We're going to get to Q&A a little bit, and I'll pull that up and see if we can go through that while we're waiting for court. But the real question here today is, what will the judge say? What will Sarah Boone say? What will the victim say? Because we're really not going to see much variance in the sentencing here. I think it's a life sentence. In fact, I'll be surprised if it's anything other than a life sentence. And remember, she was offered a 15-year plea deal to the manslaughter before trial and said, nah, let's go. And this judge knows Sarah Boone well, as she went through 8 attorneys and briefly represented herself. So the judge has had quite a lot of interactions with her. So with all of that, law nerds, let's roll the intro. I'm going to pull that up and let's go. Again, law nerds are the best research attorneys in the world. Let's go.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not. Let's get into it.
Now with pulling up this document, it's going to make it a little harder to see court, but right now court is not yet on the record, which doesn't surprise me. Does court run late? Yep, sometimes they sure do. Sometimes court runs late, sometimes they don't. We'll just wait and see what happens. But I'm going to pull that response up real quick. Let's see. It just wasn't pulling up for me. Why? Probably because I am typing while streaming, and streaming is dynamic. How are you guys doing? Are you good? How was your break? Fall break, Thanksgiving break? Did you guys have a break? Did you get to take a break? We got a little bit of a break over here, but court was busy. Did you guys see the new Quick Bits today? Quick Bits was also busy. It was a little bit more of a quick bit today than some of our other Quick Bits, which was delightful that I got to give you guys a summary. But Quick Bits has been rocking, and I love it. Soon, all the words tried to happen at once. Soon, we are going to be going to Just That Monday show and live streaming 3 days a week, and I cannot wait. So yesterday, when I pulled everything up, well, early this morning, on the court website, there was nothing there. What we now have on the docket is the defense request for downward departure, meaning to reduce the sentencing, the psychiatric evaluation, which is sealed, that's appropriate, it should be. We have the state's response to the motion for new trial, and we have the pre-sentencing investigation, which has been sealed. We knew that. That's done by the probation parole department, and they take a look at Sarah Boone, how she's acted in custody, kind of a more holistic approach of her whole life, and recommend a sentence. So we've got two things. I'm going to go to the defense first because it's only 2 pages, and then we will go to the state's motion, and I think that will get us until court pops up. So I'm going to keep an eye on court, and I'll have Miguelina keep an eye on court. I'm also going to keep the volume on, so if it jump scares us, then we know. But chat, I'm sure you will also let me know. Let's see if we can get this document to pull up in this window. Nope, sure doesn't want to do that. All right, let's do. Oh, it's so fun to switch between browsers as I'm trying to share stuff. I wish I could share 2 screens at once. It would make my life so much easier. But alas, here we go. All right, let's pull up. What are we pulling up? The defendant's motion for downward departure. I think we'll go over those before court starts because A, I'm sure you guys are interested, and B, we're gonna have a minute, so we might as well. All right, let's go through the defense motion that was filed at 10:42 a.m. this morning. Counsel, that is too late before a sentencing in the afternoon. What are we doing? Like, what even is that? What is happening? All right, I'm going to make it so you can see the document well, because I think that that's helpful. And let's see. Defendant's motion for downward departure. This means they are asking for less time, but there's a minimum here, so I don't think there's much less they can get. Vicky with an eye said, is downward departure the same as downward dog? No, not downward dog. Also, Artsy Batsy said, for some reason I was expecting you to say motion for downward spiral. Also not a downward spiral. Downward departure means to reduce the sentencing. It can also be motion in mitigation, but we'll see. For those of you who are like, Sweet and Salty's like he's pulling a Carrie Morrissey. We'll talk about Carrie tomorrow. Don't you worry about it. The defendant was found guilty and charged of second-degree murder on October 25th. The instant motion is filed pursuant to the code. The defendant asserts she's eligible for a downward departure under code sections because she requires specialized treatment for a mental disorder not related to substance or addiction. The offense was committed in an unsophisticated manner, which was isolated, for which the defendant has shown remorse. That's their whole motion. Okay, Bobo. Sure. That's the minimum's 22.5, and that's about all you're going to get. But they are coming into court, so I'm going to put court on the screen. I'm going to take a look at the defense motion and the prosecution, the state's response. I'll go through a little bit of it if we get to it before court, because they're going to argue that motion for new trial on the record. I'm always curious if counsel is scrolling YouTube. It's like, what are we looking at, counsel? Are we looking at the state's motion? Are we showing her the sentencing guidelines? Owens, what are we doing? So let's see. I don't hear any sound coming out of court just yet, but I'm going to leave that on. So if it comes in hot, I apologize to anyone wearing in-ears like me. But I'm going to pull up the motion from the government and start going through it, even though I'm not going to have it on screen. I think that that's probably our best, is to keep an eye on court. We will also hear them argue this verbally, so we will hear the oral argument. Let's see. State's response to defendant's motion for new trial. 1, Well, the defendant's not entitled to court-appointed counsel. That was their first grounds for this, was that the defendant's not entitled. Remember, part of the argument, she looks awfully happy. Part of the argument was, Your Honor, I was deprived counsel. Counsel was taken away from me. And then this group of attorneys parachuted in at the last moment, and they didn't have enough time to prepare, and the court not granting a continuance was just so unfair. Lucky Ducky, no chance for a plea deal, and they can't ask for her to be sentenced on the lesser. She was convicted of that second-degree murder, and that second-degree murder stands. The statutory minimum is 22.5. So the lowest she can get is 22.5, which really means practically, because it's 22.5 to life, what it practically means is that she can't be eligible for parole until after that 22 and a half years with whatever time served calculations and good time calculations she gets. She has been in for 4 years at this point. So she doesn't get that eligibility until that minimum is really there. But the judge can't sentence her to less than that. When he sentences her to life, she probably won't become eligible for parole till after 20 to 25 years. So maybe it's cluster B. We just did Owens's motion for downward departure. It was, she feels bad, Your Honor. Swear. Let's see. Those videos were shameful and showed her true self. Those videos were horrific. They were absolutely horrific. Doesn't parole insist that she take responsibility for her crime? Yes, they do. Barry SD said, do they offer therapy and rehab in prison? It really depends on which custodial facility you're at, what offerings they have. There are lots and lots of options. Rehab tends to be a bit better funded from the state I worked in, which was California. But there are lots of options, not only through the system, but there are also groups that volunteer to come in and provide everything from vocational training to educational training to therapy to extended education to online education. There are lots of options to keep people busy and so that they can do something productive for them while they are in custody. So whether or not she takes advantage of those things is really up to her. But there are quite a lot of options. If you guys, Kate's History Mysteries was just saying in the chat what I was thinking. If you guys have seen my coverage on Corey Richens, she went through all the certificates she's been earning in custody while she's been in there waiting for her trial. There are lots of options. And there's also a lot of religious groups that will do ministries in jail as well that will go in and counsel and do Bible study. So there's a wide variety of options and opportunities to pick from. So while they are still sitting in court, I'm going to see if I can move this over real quick. And, well, no, I'm going to have to look at the side screen because otherwise we're going to lose court, and I don't want to do that. So I wish I could bring up two screens at once. Wouldn't that be fun? So ground one, court ruling defendant not entitled to court-appointed counsel. This ground is based upon things that occurred well before the trial began and does not appear a basis for the court to grant a motion for new trial under Florida Rules of Criminal Procedure 3.600. The court decision on this ground is well supported by the facts and law. As outlined by the court's 16-page order dated June 28th, the court should not grant a new trial based on this. Ground two. Grounds two. The court denying defendant's motion to continue. The prosecution says this ground is based upon things that occurred before trial began and does not appear to be the basis for the court to grant a new motion under the Florida rules. The defendant is overstating the holdings of the cases cited. I love the legal statement for, but Your Honor, it's a reach. The defense is reaching. The defense is stretching this to the nth degree. This is all of a reach. So The defendant is overstating the holdings of the cases she cited about her right to counsel. The court's 16-page order on June 28th adequately addresses the circumstances of defendant's forfeiture of her right to counsel. They're saying that's not a reason for a new trial. The court did not abuse its discretion in denying a continuance. The case was over 4.5 years old because of the defendant's issues with multiple prior attorneys, issues created by her behavior. The prosecution's motion came out with, it's really on you, babe. It's on you, babe. It's you. It is you. Buzz Thantham, I hope you can see the court feed that I have up on screen. No, they're still waiting for the judge to come out, but all the parties are there. So we're just waiting for court to get started. They have not been called to order yet. It goes on to say in the prosecution's opposition to the motion for new trial, which I think they'll probably argue today before the sentencing, and I think it'll be denied promptly, that the underlying work on the defense of self-defense and battered spouse evidence to be used in support of the defense at trial had been done by prior counsels. So the prosecution goes on to say, look, other attorneys were working on this. So what would you like? What would you like us to do? It further says the Florida Supreme Court requires only 30 days notice prior to trial for a defendant to rely on battered spouse syndrome. In that circumstance, with an expert already working on it, they hadn't forfeited any time and they hadn't forfeited any of their rights. So there is that. Erica asked in the chat, how do custody arrangements and visitation work if a parent is incarcerated? It really depends on the jurisdiction and the family law court, but they cannot force visitation. If somebody is in custody, they can choose to allow it or not. And that will very much depend on not just her, but her ex as well, and her child, and whether her child will want to go see her in that way. But you go to a family visit room like any other visit room, depending on the custodial situation, and sit behind glass, depending on where you're housed. Some federal courts have visitation, or federal custody have visitation that's not behind glass, but most state prisons do not have open room visitation. So it really, really just depends. And I mean, I'm sure she will file motions in the family law court, but you can't force someone to bring a child to a custodial facility. The prosecution's motion continues that the lack of a continuance is not the grounds for a new trial. They go on then to talk about the quote unquote outburst during presentation of evidence. Do you remember this? There was the suitcase video was shown, and the someone in the audience had a little bit of a reaction, but it wasn't such a large reaction. We heard it on stream. Like, it wasn't even picked up on stream. We saw a little bit of maybe a sob or a noise, but it wasn't of outbursts I have seen in court. It was fairly mild. And in it being fairly mild, the defense was arguing that this must have persuade the jury in some way. And the prosecution is saying no. And the judge put on the record that it was a minimal outburst. Ako Taco said, is she in Florida State Prison, or will she move after she's sentenced? That really depends on their Bureau of Prisons. She will not necessarily be housed in Florida. With parents, they do try to keep them close, but if prisons are full, they can move them. They can move them to any state that they have kind of a compact with to move them around the states. We had inmates from California in state prison in Georgia and on the East Coast. It really depends on staffing and facilities, but they would not move from like Florida state prison to like a Florida federal detention facility. They won't switch systems. So if Florida custody or women's prisons were full, then it's possible that she would be moved to another state that they have an agreement with. So it really just depends. But she won't move into prison until she's sentenced and off and away. She's been in local custody or local-ish jail custody before that. So the facilities operate differently depending on where you're housed. I did not ever work in the prisons. It just came up a lot working in the court system. But the jails are more set up for people to be in and out waiting for trial and transporting to court and things like that, where the prisons are more set up for the you've been sentenced and you're here for a minute. So the programs are different, the things they offer are different, the way the dormitories are set up are often different. So the prosecution says, in regard to the outburst during the presentation of evidence, it says, during the publishing of an exhibit which contained the suitcase video, apparently a single family member of the homicide survivors, which is the victim's family, had an emotional reaction and left the courtroom. The undersigned's back was turned and did not witness this. The family member did not return for the duration of the evidence presentation. It cannot be said that this nonverbal single emotional outburst was so prejudicial as to vitiate the entire trial. So you're not voiding the trial because of it. It said the trial court's findings on this situation are subject to an abuse of discretion standard, which is a very hard standard to find with judges. Abuse of discretion is a fairly high standard. And that abuse of discretion standard is not going to be met by this, right? It goes on to say the undersigned's recollection is that at sidebar, there was no request for a curative instruction, but rather a request to excuse the jury. The jury was excused, and the member of the victim's family had either excused herself or then excused herself. The allegation was then made that this was intentionally staged by the state, which is fighting words when the defense is accusing the state of staging something. Victims' families have a right to be present in court. And sometimes they think they can. And you don't really know how you're going to respond until it happens. And people want to think that they can be, that they can see the things that they're going to see, even if they've seen them before. But it can be a very visceral response when it hits you. And you might not want to cry. You might think that you can contain it, and then things hit you sideways. I mean, I was prepared. I took an entire box of Kleenex to go see Wicked, and I was still caught off guard. So, it is what it is. There are emotional responses to things that you can't prepare for. We actually saw the judge talk about this in the Corey Richins case when allowing there to be in-person voir dire, saying that the jurors can't really appreciate what media attention on a case is like if they don't come into court where the media is there. Like in abstract, it's real easy to say, oh yeah, I'm fine with it. And then you walk in and there's all these cameras and you're like, oh my God, my anxiety is 10 out of 10. You think it's going to be fine. And then you get caught. So this is not a huge ground. This is not a huge grounds. And I think it was actually kind of gross to pull it up. Mercedes is just coming in saying, has it happened yet? No, court hasn't started yet. Look, court was scheduled to start at 1:30 local time. They have not gone on the record yet. The judge might be reading the motions that were filed today. And if the judge had set aside time at 1:30, that might be 1:30 Eastern time, that might be when the judge sat down to read these if he just finished his morning calendar. Court's dynamic. The first Monday after the Thanksgiving holiday is a shit show. I'm actually really surprised they scheduled this sentencing today because it's a shit show. Especially depending on how different jurisdictions handle warrants, because courts closed Thursday, Friday. So Monday's wild. All right. It goes on to say it was neither intentional nor is it uncommon that a homicide survivor, and what they are categorizing the family members as that, not meaning that they are indeed someone who survived a homicide, because then it wouldn't be a homicide, but under the survivor statute or whatever the Victims' Bill of Rights is called in Florida, I'm imagining there is a homicide survivor statute, and that is why they are titling it that way, because this is a family member of a victim. So they then talk about the other cases where this has happened, and some of the cases that they are talking about are quite difficult evidence. And then they talked about Dr. Werner's testimony. And the prosecution goes on to say that also should not be grounds for a new trial. And then ground 5 was alleged prosecutorial misconduct by essentially making a second closing argument instead of a rebuttal argument. This was the funniest fucking argument. I've never seen defense make this argument. It's absolutely hilarious. It's like, but Your Honor, their rebuttal was so good. It was basically a second closing, right? It rebutted the shit that you said. That's what a rebuttal is. So here's what the state says. The defendant, much like her motion to suppress statements, cited no authority to support this ground for being improper. Your Honor, they don't even have any law. Oh. There's no law, Your Honor. There's no law. It goes on to say, this, of course, is no bar to her again alleging prosecutorial misconduct. The state's like, hey, coming in hot. Is he showing Sarah text messages? Don't those look like text messages? Also, remember, Sarah had a number of people on her defense team and an investigator. I imagine that as she's turning her head, talking to people that are behind her, that they are part of her defense team. So it doesn't seem like she's talking to anyone in the audience, but the prosecution's like, coming in hot. Sarah's not allowed to have a phone. He's showing her something, but she doesn't have the phone. It's in counsel's hand. I don't know what he's showing her, but he's showing her. Continuing on, it says, quote, the state strategically broke up its closing arguments. The first argument was nearly entirely devoted to why the defendant was guilty of second-degree murder. That's the way I like to break up statements too. That's the way I like to break up statements too. The first one focuses on, as my mentor used to say, the crime, and the defendant's connection to the crime. That is what your first part of your closing should be. When you don't know what to write in your closing, the crime, the defendant's connection to the crime. You tell the jury what the crime is. You point to the elements of the crime. You talk about the facts of the crime. And that is the focus of the first part of your closing. And then in rebuttal, you bring all the other observations so the defense doesn't have a chance to talk about them. They got to come up with their own stuff. They know you're going to talk about the crime. They know you're going to talk about the elements. They know you're going to talk about, why the defendant is the person. But they don't know you're necessarily going to grab the suitcase and kick the side of it, showing how hard-sided that case is. They don't know you're going to do that. So why give them a chance to respond to that? Keep that demonstration for yourself. That is your gold. So they're saying the state strategically broke up their closing arguments. The first argument was devoted to why the defendant was guilty of second-degree murder. Obviously, there is some inevitable crossing into why it was not justified and why the defendant lacked credibility, but that was largely left for rebuttal. The defendant's nearly 2-hour-long closing, dude, that closing felt so long. The defendant's nearly 2-hour-long closing argument centered on why she met the criteria for battered spouse syndrome. It touched upon why this made it objectively reasonable for her to fear imminent harm or death if the victim escaped the suitcase, but failed to address the applicability of the Florida statute 776. Yes, 776.041 to the facts. And the facts were that she left the victim shut in a suitcase after he said he could not breathe and asked to be let out so she could make him feel how he made her feel in the past. And she could say whatever she wanted to him, and he had to listen to her. It is a completely fair rebuttal to distinguish the difference between the defendant's subjective belief that something is necessary versus objectively reasonable for a cautious and prudent person in her circumstance. Likewise, if it was fair to attack her credibility as a witness, as that was the foundation of her defense, and to point out that even if the defendant's arguments were accepted, she failed to comply with the statute. So that is the sum and substance. We didn't go line for line in the motion from Attorney William J. I'm starting to hear some noise out of the court. That's not on my end. That's not on your end. That's out of the court. So we'll see if they're coming onto the record soon, but I was just getting some little pops from the court. So we will see where we go from there. Olive asked, will there be victim impact statements? We'll see. There there likely will be, but we always kind of see on the day. There seem to be a lot of family in court, but it will be up to them to decide whether they want to make impact statements or not. So we will see. But I expect that there will be at least one or two. Maybe those sounds are coming from court. Maybe from her, from his children, I would think. So let's see. Is that what he was talking about? I couldn't follow his closing argument. Caven, I agree with you. I had a hard time following the defense's closing argument. So that was absolutely tough. So let's see. Candace said, I wonder how many times she says it wasn't intentional. Probably more than a fair few. All right, it looks like we are getting back into court. Yay for us. Hear ye, hear ye. Court is now in session. Just to point out, because it's going to be asked, the people sitting behind the judge on the bench are generally law students from his trial advocacy class. They were there during the trial, and they are there now. The sound is clipping like, I don't even know what. That is terrible. Give me 1 second. Miguelina, are you hearing that on your end? That is the worst clipping I have ever heard, and I'm trying to figure out if it's this feed or not. It's awful. I've never heard clipping that bad. I'm gonna try to switch feeds real quick. Yeah, I'm gonna try to switch feeds real quick. All right, the judge is on the bench. I'm gonna try to switch feeds. That sound on my end is just clipping in and out. So give me 1 second and see if it's a little bit better. No, why won't this copy and paste? Why is my keyboard like, we're not gonna work? Streaming is dynamic. The court just came out. Keyboard, we would like to go, please. Let's see. All right, let's see if this audio is any better. Oh, there's no audio on that at all. Well, that's not very helpful. None. Not a single second of audio. There we go. Oh. Ouch. Ouch. Ouch on the audio. All right, let's see. Court again. Sorry, y'all, is dynamic. We're going to try this one more time and see if that is any better. All right, let's try that one more time. And hopefully it is not that bad.
Calling State of Florida versus Sarah Boone, 2020 CF 2603.
There we go.
State.
Chief Cacciatore on behalf of the state. William J. for the state. Defense.
James Owens for Sarah Boone.
That
Ms.
sounds
Boone
so much
is seated
better.
at counsel's table. Ma'am, if you could please raise your right hand, Madam Clerk's going to go ahead and swear you in.
Solemnly swear or affirm the testimony about to give will be the whole truth.
Ma'am, can you state your full name and date of birth for the record for us?
Sarah Boone, 10-10-77.
We are here for a sentencing. The jury returned a verdict on October 25, finding you, Ms. Boone, guilty of murder in the second degree. We're running a little bit late this afternoon. I apologize for that. I was in court all morning and took the opportunity to review all of your submittals from earlier this morning. Mr.
What did I
Owens,
say I
including
thought
the
was happening?
victim or the character statements, the psychological evaluation by Dr. Harper, the motion for downward departure.
Today will be a shit show.
Motion for new trial and the state's response to same. Before we proceed with any sentencing in
Motion
this
for new
matter,
trial?
the court needs to address the defendant's motion for new trial and the state's
Let's go.
response to the defendant's motion for new trial. Anything in addition you'd like to argue at this time,
Yes,
Mr.
please.
Owens, over and above
I wanna
what is contained
hear-
in your motion, sir?
I want to hear what they have to say.
State. All right. After reviewing the motion and the state's response to same, the defendant's motion for a new trial is denied.
Yeah.
Based on the court's review
Boo.
of the record, the court's participation in the trial,
was fast.
review of all the evidence, and the court's prior findings and rulings at trial and prior thereto. With that,
Denied. Moving on to
I believe that
sentencing.
We're prepared to proceed with sentencing at this time. The court has reviewed the pre-sentencing investigation prepared by the Department of Corrections Are there any housekeeping matters that we need to address, Mr. J or Mr. Cacciatore, before we proceed?
Not from the state.
Are there any housekeeping matters from your side of the ledger, sir, that we need to address, Mr. Owens?
Judge, I do have, one of the witnesses wants to appear by Zoom. She lives up in Minnesota. That's a
We don't have an objection to that. One of our witnesses will be providing an impact statement, would also like to appear, of course, virtual.
Okay, so stipulated. If you need it, just let Anita know, and I can have her email it to you right now, the link.
we do have the link. She's waiting to get on.
Who might it be, sir? Several people. Sure.
It'll be Lana Albert.
She is here, sir. She's
So
in
there's
the,
going to be
she's,
statements from the
viewing,
defense as well.
Her camera's off and she's microphone is muted, but she's in the lobby.
We are gained
All
up
right,
as
with
much
that,
as we
state,
can.
you may proceed.
We are gained up as much as we can.
At this
We are going to the state's argument for sentencing.
time, we would like to take an impact statement from, I believe, Anna Torres, who will be appearing virtually.
All right, we're going to impact statements before they argue.
I see several guests, but I do not see a Anna Torres in the virtual lobby, sir.
Well, I think while maybe she's having some issue logging on, we have also in-person witnesses.
We can proceed with those first, sir.
The audio is a little choppy, but that's on all the feeds. The feed itself is a little bit choppy, so it is what it is.
Please.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Ma'am, good afternoon. Could you state and spell your name for the record for us?
My name is Blanca Torres.
Okay. Ma'am, you can go ahead.
I just want to tell Sarah Boone that I don't hate her for what she did.
Wow.
And I always remember that evening when that lady came into my door and she knocked at the door. And she asked for my name. I said, I tell her my name. And then she said, "Can I come in?" I said, "Okay, yes." And she told me to sit down. I never think that was
What the
going to be
police were
my
going to
son.
say. Yeah.
And then she said my son was dead. Since that day, I can sleep. It's hard for me to remember that moment. My son is not here no more. She don't only kill my son, she killed a father, a brother, an uncle. It's been hard. And my family, because all the brothers, they will always work together. But now it's like something real. Love is missing. Sometimes when I look out the window, I'm waiting for him to come and say, "Mom, I love you." She was always there. She called and called me. I missed us, Mommy. The last time that I talked to him was at 12 o'clock in January. New Year, he came to my bed and said, Mom, he woke me up and I said, Mom, I love you. Happy New Year. And since that day, I don't see him no more. He was my son. I love him. And I miss him a lot. My family miss him a lot too. But I don't hear him. But you know what? I was blessed. She ain't gonna be blessed like me because I have my son. I raised him. I have his children, my granddaughter, my grandson, and she don't gonna be able to have that. And I did. I raised him. He wasn't perfect, but he was a good son. Thank you.
Thank you, ma'am. State anything further from this witness?
No, Your Honor.
Defense?
No, sir.
Thank you.
Some strong words from George Torres's mother about how blessed she was to get to raise her kids, her grandkids, and that Sarah Boone will never have that because she won't get to raise her son. If anything
next
is going to
victim impact
impact
statement.
Sarah Boone, I wonder if it will be that. And though victim impact statements are hard, they are so necessary. They are swearing in everyone for
Ma'am,
their
could you
impact
state and
statements.
spell
That
your name
varies
for the
by
record for us,
jurisdiction.
please?
Victoria Torres. My name is Victoria Torres. George, my brother. Unfortunately, my family has experienced two horrifying tragedies. I just want to make George deserves justice. As far as my other brother and Sarah deserve to rot in jail. Sarah has caused a lifetime of pain, a lifetime of horrible images, a lifetime of hearing my brother George plead for his life. This is just this moment for all of you. For me and my family, it's forever. Such a simple thing as using a suitcase is so triggering. I try not to close it all the way. I leave at least like 2 or 3 inches for the zipper. And it might sound crazy, but it just helps me. She really has flipped my family's life upside down.
Yeah.
And I just hope that we can truly get justice for my brother. And I just want to tell the team thank you so much for everything they did. Thank you.
Thank you. State anything further?
No, Your Honor.
Defense?
No, sir.
Thank you.
Your Honor, could we see if Ms. Anna Torres is able to make it online?
They're going to check and see if one of the...
Do not see an Anna Torres in the lobby, sir. I have lots of guests, HHSA, Mr. Beck, Lana Albert, Jason Gunn.
So I imagine either the prosecutor or the victim impact coordinator is going to try to contact, I think, one of George's daughters to see if
Is there a cap to the link?
she was able to get into
Not to my knowledge.
the Zoom so she could give
Yes.
her statements by Zoom. But you saw George's sister say, you know, Sarah Boone deserves to rot in hell. And that's not or rot in jail is what she said. My apologies. But it's not an uncommon sentiment from families because they carry this with them for the rest of their lives, no matter what happens to Sarah Boone. And whatever Sarah Boone gets sentenced to, it doesn't change a ton for the victims' families because they still have to live with it every single day. For all of you in the chat that are saying it's hard to listen to the impact statements, it is. But it's really the only time in this process that the victim gets a voice and that the defendant really hears the impact of what they've done. And it's hard. And it's something judges do day in and day out. I've seen judges tear up during impact statements. It's not an easy thing to sit in court for. I always just hope that for families, it's cathartic to have someone hear them. Like to have a judge listen to them, hear what they have to say, and to have the opportunity to choose to speak. So, not the Kay in the chat said, not the Freudian slip. I mean, jail, hell, it just, the words are very close. Oh, Lauren, there were times I was doing everything I could to not audibly sob in court. Yep, there were definitely times during impact statements that I was challenged. I was challenged reading. Sometimes people would write their impact statements and ask if I could read them to the court. And those were often written in the first person. There were times those were very difficult for me to read. So some judges were more patient than others. And I'm just like, look, this is heartbreaking. So yeah, there are times it is tough. But it's one of those things when you are watching, when you're watching trials, when you're watching any court cases and interviews and witnesses, when people's emotion is genuine, you can feel it. I mean, you can feel it. How it impacts you is going to vary, but you can feel it. You can. And so there's times when you're looking at witness impact statements or not impact statements, witness testimony or defendant testimony, and you're like, this isn't ringing true because you don't feel anything. So it really just depends. They're waiting to see if they can get that connection on Zoom. And we'll see. So I'm going to answer some questions as we are waiting. So let's see. Can lawyers object during the victim impact statement? Hold on. I mean, I'm sure they can. I don't know why they would. Like, if there was ever really an issue with something that was being said, the court would rein that in. So
Yes, sir, Mr. Cacciatore.
Mr. Owens, given the fact that the victim's daughter is having difficulties with...
Is that her, Ana Victoria Torres?
Yes, sir.
okay, the victim's daughter
Who it
is
All right, ma'am, good afternoon. Can you hear us?
now available.
Good afternoon. I can hear you.
Okay, could you please state and spell your name for the record?
My name is Ana Victoria Torres, ANAVICTORIA TORRES.
Thank you, ma'am. I understand that you'd like to provide a statement to the court at this time. You may proceed.
Okay. Okay. So I'll be speaking for myself and my two siblings. The murder of our father has impacted us on so many levels and in different ways. I myself, for the first year, would wake up screaming every morning or night, wishing I was having a nightmare only to wake up to remember all over again that my father is gone and I'll never be able to hear him say he loves me ever again. To know my siblings have been affected in such a way that they are now different. They have had a piece of their heart ripped away from them, all while her son gets to hear his mother's voice and see her alive is pathetic. Because of you, Sarah, my sister is heartbroken. Because of you, Sarah, my brother is left wondering when he will ever see his father again. The loss of my father has left me with chronic depression and anxiety. Seeing any moments of fatherly love or kindness being shown between others in real life or even on TV leaves me in complete shambles. Seeking therapy was a must in order to navigate through my workday without a random breakdown. Thoughts of my father's demise still enter my mind ever so often. I'm left either angry, sad, or sick to my stomach to think of how his final moments were. George Torres, my incredible father. Not only was he my father, but my best friend. My personal comic provided me with wisdom and knowledge, creative and loving dad, an older brother, an uncle, a cousin, a friend, a son, and above all, our father. He was human and deserved to be treated as such. My father, George Torres, was one of a kind, an absolute gem. Unfortunately, his light was dimmed on earth by evilness, but with us, we will forever make his name live on. Especially Sarah, I pray that you see his face when you see him at night. That is it.
No, Your Honor.
Anything further of this witness?
No, sir.
All right, thank you, ma'am.
Thank you.
Anything further?
No other impact statements, Your Honor.
Thank you. Any other witnesses or evidence at this point in time, state?
No, Your Honor.
And that's the
Mr.
end of
Owens,
the impact
you may
statements.
proceed, sir.
Ms. Diane Smith.
And we're going to have impact statements for the defense.
Judge, what do you want?
I have no issue with her being at the podium. If you want to move about the well to conduct your examination, that's fine, counselor. Ma'am, come on up.
Okay.
Come on up to this podium right here, ma'am. If you could, raise your right hand. Madam Clerk's going to go ahead and swear you in.
You solemnly swear or affirm not to give the truth, the whole truth.
Ma'am, could you state and spell your name for the record for us, please?
Diane Smith, D-I-A-N-E-S-M-I-T-H.
Okay, thank you very much.
All right.
Counselor, you may inquire.
Ms. Smith, tell the court a little bit about you.
I was a chaplain at the 33rd Street Jail for 30 years.
And have you been a chaplain at the jail here in Orange County?
Yes, Orange County Jail
Is that the same
for
jail
30
you're
years.
referring to?
Uh-huh.
And during that period of time, did you have occasion to meet with Sarah Boone?
I did.
And was it over the course of how long?
I've known her 4 years.
And this is someone who's worked with Sarah in the jail.
Tell the court what you'd like to say.
Y'all, I'll be right back. I forgot
Well,
my
I
notebook.
first met Sarah. She came in. We have a Christian dorm, and Sarah enrolled in our Christian program. And she was in my classes for a year. And she was very sincere in her efforts to change her life and to be a better person. And I found her very helpful. She was kind and good to people. She loved to serve. And she helped the new girls that would come in, the younger girls. She would mother them and be very kind and very helpful. And then after she graduated from the program, I was her counselor for the other 3 years. And I always found her, very sincere and, trying to do better. I spoke with many inmates that knew her and was associated with her. And they spoke very highly of her and said that, she was helpful and kind and tried to help other people. And I just found her to be, very sincere and trying to be a very good person and change and help people.
Was the Bible involved at all?
Oh, yes, it was all spiritual. Yes, it was spiritual growth plus character.
We've reached
growth and
the she
character.
found Jesus
Trying to just be a
part
better
of
person in
the
general. She was
defense
She liked
statements.
to serve other people. She would help the girls wash their clothes and show them around and teach. But spiritually,
Oh, so she was in charge.
she grew very, very great spiritually.
Good. She's probably going to need it.
Hang on, ma'am, just 1 second.
Ma'am?
Hang on just 1 second, Ms. Smith. State any questions.
No, Your Honor.
All right, thank you, ma'am. I appreciate you.
State any questions? The state is like, nah.
I'd like to call Christina Pena.
These are I'm sure people Sarah wanted to call. Hearsay is not really the issue here since it's being taken into consideration of the defendant's character. So it's not really
Ma'am, come on up if you can. Raise your right hand.
the
Madam Clerk's
evidentiary
going to go
rules
ahead and
at
swear you
sentencing
in.
aren't the same.
Affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Ma'am, if you could state and spell your name for the record for us.
Christina Pena,
Where would you find my pen, too?
Cristina Pena.
All right, you may inquire, sir.
How old are you?
31,
And where do you live?
Orlando.
Now, it's my understanding, Ms. Penna, that you were in the county jail with Sarah Boone.
Yes.
How long were you
Putting all that
in
woman's
the
business.
same cell together?
Yes. I was in there for 4 years, but we were together for 3.
Defense brought in her celly?
And, I understand ultimately the charges against you were dismissed. And so you were released on what day?
April 4th this year.
2024?
2023.
2023. So you've been out for a pretty good while.
I've been out for like 6 or so months now. Yeah. Since April
Okay.
of this year, actually. Sorry.
April of 2024. And you said y'all were bunkmates there together for about 3 years?
Yeah.
I would assume that y'all got to know each other pretty well.
We did.
Okay. And if you could, if you'd like to speak on her behalf to the judge.
Yes. Sarah's one of my best friends, my only.
Take your time.
She's helped me a lot. Spiritually and like growing and she helps everybody. She's always, I don't know, spirit. She helped me a lot, and she would come to me. She talked to me all the time and pick me up when I was down, or if I didn't know something. She just good. I don't know. She was a good person to me. She just mistakes happen. She always helped. She always helped people. She was always helping everybody in the dorm. She even like her artwork. She did art. If anybody needed any help or needed anything, they'd come to her and they'd help. She'd help them. And even if they, did wrong to her, she would still go back and help them and praise with them and pray over them and everything. It's just
And was she a little bit older than you?
yeah.
How much older was she?
40 or 40.
What?
Did you think
Owens.
of her as maybe an aunt or a big sister? What
A
was
big sister, yeah. She
What?
was like a big sister. Like a sister I never had. Because I have brothers, so I never.
The
we
sister she
clicked
never
right away.
had.
I don't know. We'd be walking out in the backyard, and she just would always try and talk to me. But I'm a quiet person, and I don't trust a lot of people. So for me to open up and trust somebody, it's a lot. So.
And obviously y'all were there under difficult circumstances.
Yeah.
She assisted you in getting through that.
Yes, and she helped me a lot with my case, and I would help her with with hers too. We're both. Justice is not what it is. I don't know how.
Bless you.
This judge.
We both helped each other out. I don't know. It's
Ms. Mignon, I appreciate it. Thank you.
Any questions, State?
No, Your
All
Honor.
right, thank you, ma'am. I appreciate you.
Ms. Hill?
More.
Judge,
Yes, sir.
after Ms. Hill, I want to take.
Yes, sir.
Sarah just has a bunch of people she wants to come on in. Okay.
Swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Ma'am, good afternoon. Could you state and spell your name for the record for us?
My name is Mariela Hill, Mariela, last name Hill, Hill.
Thank you. You may proceed, sir.
Ms. Hill, briefly tell us a little bit about yourself.
I met Sarah in jail. I spent 3 months in jail and went through a lot of unfortunate circumstances.
All right, now This was in the Orange County Jail here in Orlando?
Orange County Jail.
And when would that have been? Do you recall the dates?
Yes, it was April, from April to June of this year.
It's not a reunion, Sarah.
Yes.
And did you develop a relationship with Sarah Boone over the course of that 3 months?
Yes, yes. We met when I was moved to the B dorm, and
Oh, we banged. Thanks, y'all.
With what I needed to complete, and one of the CEOs pointed to Sarah to help me out. And since that moment, we became really good friends. And she was so helpful, so kind, so respectful, and loving, not just to me, but to everyone. And I have nothing but good things to say about her, her character, her loving heart, and how deep her faith is.
I don't know what they just did to the audio,
Believing in justice. That's what I believe.
but it got miserable.
State any questions?
No, Your Honor.
What you missed is her BFF from jail saying that Sarah was helpful, kind, loving, and has a very deep and profound faith. So, okay.
Thank you, Ms. Hill. I appreciate it.
Oh, and now we are too loud.
Ms. Albert, good afternoon, ma'am. Can you hear me? This is Judge Kranick, and if you can, I would ask you to turn on your camera and unmute yourself at this time, please.
Sir, how do I unmute turn on my camera? I know how to unmute, but I'm not sure how to turn the camera on.
The volume down.
Did he just say turn the volume down? No, Owens, that's not how you turn on the camera.
Is that better?
When you join the link, there should have been an option for like a pull down on the left-hand side of the screen for you to open on or turn on a camera. I don't know what device you're appearing on, if it's a cell phone or a laptop.
It is an iPhone. Should I try to re-enter the room?
Yeah, try to do that. There should be an option for you to pick a camera. And you'll either select the default camera, and hopefully we'll be able to see you at that time.
Okay, let me just give me 1 second.
Sure.
No, if they're going to be on the record for sentencing, they do need to show their face. So that's why they're going to need to turn the camera on. Also, I am all for people having a strong faith. I am very much not for it becoming convenient at sentencing. So that gets tiresome. We are a little scant behind real time, so I'm going to zoom us forward where somebody is getting back into the Zoom room, because if they can zoom, we can zoom.
Camera, it's saying front camera. I chose it. It didn't show my face or anything like that.
Okay.
My technological skills are limited. State?
Judge K said my technological skills are limited. Trying to tell someone else how to use Zoom from a phone remotely is very hard. It's like you got to swipe a little bit to see it. Oh, that's funny.
I have no objection to the witness making their statement.
And that's the state would be.
Appreciate it. All right, Miss Albert, good afternoon. If you could just
would
state
be
and
the
spell
party that
your
would
name
object
for the
to that,
record
but they're
for
not
us,
going
please.
to.
Certainly. Lana, Lana, Albert, Albert.
Okay. All right, Mr. Owens is going to ask you some questions. And if you could just answer them, ma'am, I would greatly appreciate it. Sir, you can proceed.
Miss Albert, do you have the ability to turn your volume down?
Yes, I just did. I can't hear you very well when I do that, though.
Right.
You can't hear me?
Right.
I can hear you, but very, very quietly.
How about now?
Yes, I can hear you. Am I okay?
Yeah, you sound a lot better. You were too loud earlier.
Okay.
Can you hear me okay?
Jesus.
I can hear you.
All right, Miss Albert,
Can you
tell
hear
the
me
court
now?
a little bit about
Can you hear me
yourself
now?
briefly.
Can you hear me now?
Well, I live in Minnesota. I currently have end-stage renal disease. Before I became disabled, I was a business owner in the Twin Cities here.
And
All right, and how old are you?
I am 50 years old.
All right.
I'm
And
sorry to hear that.
you're considered disabled?
Yes, I am.
All right. And have you had an occasion since this event to establish a relationship with Sarah Boone?
Did they bring in a pen pal? Is this someone who's a pen pal because they watch this case online? Tell me that's not what's happening. Tell me this is not what's happening. This is someone from Minnesota. No. This can't be.
Yes, I have. We have been friends for the past a little over 11 months.
And how do y'all communicate?
We've communicated a lot of phone calls, lots of tablet back and forth, and a lot of letters as well. I'd say many hours of time spent with each other.
All right. And do you want to speak on her behalf here today?
I would, please.
I have seen a lot of things happen in court. What I have not seen is someone who has become pen pals with a high-profile inmate actually speak on their behalf at their sentencing. The convergence of internet and reality right now is a little bit too much for me. Look, this person's like, we talk on the phone all the time. Yeah, I bet you put money on their books too. I bet this person puts money on Sarah Boone's books. And Sarah Boone's like, of course I'm going to call you. I wonder how many other people Sarah Boone calls who also put money on her books. Because the one thing that is clear to me about Sarah Boone from watching this trial is that Sarah Boone is 100% a survivor. So if Sarah Boone needs to be friends with the people that are writing her in custody because they're going to put money on her books, she's sure as fuck going to do it. This is her jail pen. This is her jail pen pal. I'm gonna shut up. I can't wait to hear this. And now I am so sad that they didn't fight harder to get the camera turned on the phone.
All right. Would you please tell the court what you would like for the court to know?
Thank you very much. And thank you very much, Your Honor, for the privilege of speaking on behalf of my friend Sarah Boone. I also want to extend my heartfelt condolences to everyone here affected by this terrible tragedy, which has brought us all here and listening in. Many.
Caller, this isn't a radio program. Hi, Larry. Longtime listener, first time caller. This tragedy that has brought us all here together, watching along.
Articles and videos and opinions of Sarah have gone out in the airways and on the webs. Opinions that have been formed and commented.
On the webs? On the webs? I'm going to back up. I'm going to shut up. I'm fucking flabbergasted. I'm flabbergasted that this is happening.
Many hours of time spent with each other.
All right. And do you want to speak on her behalf here today?
I would, please.
All right. Would you please?
Yep, chat. You're right. Chat, you're right. Somebody somewhere in the comments is going to be like, girls, stop pausing and let us listen. I get it. But chat, you're absolutely right. This is code red. When was there ever a more code? I mean, we've had a lot of code reds. This is one of those times. This is one of those times. We're going to code red this. I am stunned that this person has befriended her not 4 years ago, in the last 11 months, as this case was very prominent in the media. Stunned and shooketh. For those of you that are new here, hi, welcome. Thank you for coming for the commentary. That's what we do here. Code Red is flashy, but the flashing does end when the music ends. So get ready. We're granted. Motion granted. We're going to Code Red in 3, 2, 1. We're just gonna roll court.
Tell the court what you would like for the court to know.
Thank you very much. And thank you very much, Your Honor, for the privilege of speaking on behalf of my friend Sarah Boone. I also want to extend my heartfelt condolences to everyone here affected by this terrible tragedy, which has brought us all here and listening in. Many, many articles and videos and opinions of Sarah have gone out in the airways and on the webs. Opinions that have been formed and commented on so much that it's hard not to give into the temptation to treat people like a comic book or a fictional character. In the case of my friend Sarah, the words narcissist, Karen, villain, many other things, they roll off the tongue with little regard to the humanity that is dismissed so flippantly. And under a lot of circumstances, I was one of those people, as I have a love of true crime. And becoming friends with Sarah has shown me that there's a lot more depth to the people I see on the screen. I'd like to share with the world and with the court about the Sarah Boone that I know.
And that's why they're here, isn't it? Giving an impact statement. I would like to share with the world.
Sarah Boone is a kind, honest, and good person. The Sarah Boone I know is one who loves animals, especially the kind who are damaged and defenseless. How many of us would take in and pour love for a hearing impaired and a sight impaired pair of dogs? She has a natural instinct to help reach out and give of herself. Her time and energy and love, especially to those who are hurting or damaged.
How much money have you put on her
books? You all have
books?
seen her fight for her own life and truth here.
How much money have you put on her books?
I tell you this, she fights even harder for those she loves, giving time, attention, and companionship without a single thought for her own gain or what somebody can do for her. And one huge example is in the matter of our friendship. As I said before, I have end-stage renal disease caused by a genetic illness called polycystic kidney disease. As my life has progressed, things I have taken for granted have been taken away from me. I could not appear in court in person because I can no longer walk, as my dialysis treatments have affected the circulation of my legs and has confined me to a wheelchair. To say that my life has radically changed is an understatement. Through it all, I have many friends and family I love and cherish. Sarah has distinguished herself differently in this way. In the course of getting to know her, I started sharing the...
Because all your calls are recorded? Is that how it's distinguished? Because when you talk to her, it literally says this call is being recorded? Or is it because she's the only one that calls you collect? I have so many questions.
Progressing state of my health. It was like lightning had struck her. The moment Sarah had learned the depth of my struggles health-wise, she straight up offered strenuously to donate a kidney to me. I got to tell you this. I hope she's not mad for me.
You know, if she had offered to donate a kidney and had actually donated a kidney, she'd be talking about it at her sentencing, right? Nick, I see you in the chat.
Sarah had learned the depth of my struggles health-wise. She straight up offered strenuously to donate a kidney to me. I got to tell you this. I hope she's not mad for me showing this, but she had no hesitation, no concern over personal risk or personal gain. I want to convey to this, out and around the world, that is merely offering is a good and heroic act. I've had many friends. I've not had one outside of my brother who has offered me a kidney. That is huge. I don't have anything of equal value to give to her.
You know she's going to be in prison, right? Like, she can't fulfill that promise. So Promising something that she doesn't have the capacity to fulfill is what? Y'all are going to make me start quoting Wicked. I'm going to start doing it immediately.
And that's not the actions of a narcissist. She did it as a reflex action as a good person.
Uh-huh. Tell me more.
After the verdict came in October, we spoke that night.
Oh.
And I hope Sarah doesn't get mad at me again for disclosing this. But
the internet wants you. Spill the tea. We're spill the tea. We've slipped into an alternate fucking reality where your pen pal is calling in so they can have their 15 minutes. So just spill all the fucking tea. Scorching hot.
Out of all the shock and seriousness of what had happened in the court, the thing that made her emotionally break was that she realized she could no longer be a donor to me. I mean, I was sitting there like, hey, you know, it's going to be okay. But she was so broken up, she couldn't help me. That's a friend. She is not, nor does she come up anywhere remotely close to being a narcissist. And one more thing before I go. Social media has worked to rip the blindfold off of Lady Justice, to take the sword out of her right hand and start assassinating Sarah's character. However, the scales are the balance.
You guys,
as it says in Psalm 85, mercy and truth
are
met together. Righteousness and peace have kissed each other. Justice isn't justice without mercy. Our pursuit of righteousness isn't complete and right without peace. Thank you, Your Honor, for the honor of speaking for my friend Sarah Boone. I hope that your justice is mixed with mercy here today. Thank you.
State, any questions?
No, Your Honor.
Any follow-up, Mr. Owens?
No, Judge.
All right. Thank you, Ms. Albert. I appreciate you.
I'd like to call Dr. Harper. You want her on the stand or?
I'm okay with her on the stand.
On the stand?
No, she can be right now. Yes, sir.
I am so flabbergasted. Apologies, everybody. I am so fucking flabbergasted. I am
No, she'd
shocked.
be at the podium.
I am absolutely shocked. The judge is. The
Doctor, good
judge has
afternoon.
got
If
to
you could please
be
raise your right hand. Madam
stunned.
Clerk's going to go ahead and swear you in.
No, I didn't flip a table.
If you could, doctor, state and spell your name for the record for us,
But
please.
it does feel like it's
Dr.
going to
Julie
snow.
Harper, JULIEHARPER.
Wild.
Thank you. Counselor, you may inquire.
And Dr. Harper, we all know we were here
Jeez.
a few weeks back for the trial, and your testimony, so the judge knows quite a bit about your testimony. But if you could, I know that you prepared a report.
Sarah's perception management is on high.
Report is read, the state has a copy. And I don't know if you want to refer to that or just speak on about Sarah Boone and what she did to assess her, and then any opinions that you want to.
Right. I think that during trial testimony, I reviewed all of the documents, excuse me, and all of the records that were available. They're documented in my report as well. In addition to the forensic clinical interviews that I conducted, I also have had the opportunity to talk to her brother.
I've never seen
Philip Paulson in the interim since
anything
the trial,
this wild.
and I included his information.
Ma'am,
in
I've stopped
my
listening.
report as to her family background.
If you could,
The doctor submitted a report.
synopsis of what your findings are, or what you uncovered, maybe.
Okay.
Brother, whatever you think the court is relevant to his decision.
So referring to the summary section of my report, I'll keep it a brief, but I'll outline the highlights that I feel like haven't been conveyed before, which is an understanding of Ms. Boone's early family life, in that she is the middle child of her parents' union, and that her parents did not have a happy marriage. They didn't provide an opportunity to have a good role model as to how to have a partnership together. Ms. Boone was born in close proximity to her youngest brother, 11 months apart, and in my clinical experience and training, I would say that that disrupted her attachment with her mother, some being close in proximity with her younger brother, whose temperament just seemed to suit a relationship with her mother better than her own. So ultimately, Ms. Boone...
You're saying it was difficult for Sarah to have a relationship with her mother. Okay.
Bonded with her father, though he wasn't described by either child as an affectionate person. He was somebody that was there for her at sporting events and more of a primary parent for her in that way. His untimely death by heart attack during her high school years was marked by her brother as a turning point for her in how she was acting at home. Her demeanor, her relationship with her mother took a turn for the worse as she was not coping well. She was using substances based on what her brother was saying. And it is my opinion that that early lack of foundational relations with her mom and not feeling very secure, the death of her father, destabilized her. That's a period of your life when you're leaving high school, when you should have formed a very solid foundation to go out in the world, and I don't think that that's what she had at that moment. She bonded easily with Mr. Boone, and you can see that there are elements of that early difficulty with her relationships because she took on a parentified role, in my opinion, during that relationship. And therefore, there's a power imbalance in that she was making decisions and not, again, having an equal relationship. I think that that led her to a sense of being a need to be right, a need to feel like she is the one that's making good decisions, to have some ego support by being in the right all the time with Mr. Boone. And I think that that led to some behaviors that she carried over into her relationship with Mr. Torres, in that she's parentified around him and acting more like a parent-child relationship, being a facilitator of housing and applications for jobs and things like that. So again, there's a power imbalance that I think was very seriously misaligned as her brother and
Right. She being the one in
property
power.
manager of their apartment had verified they saw her being abused, physically abused in serious ways, or the effects of the abuse in bruising or calls to them. It is my opinion that she called for help, but when people got tired of her not leaving Mr. Torres, they stopped responding to those calls. And basically, Ms. Boone handled things on her own. And as other people with healthier boundaries probably would have left, she being acting out the pattern of intimate partner violence did not leave. She stayed long past when it would have been smart for others, or others would have said to leave, sorry. The undergirding of that not leaving the relationship is a long-term anxiety problem that became post-traumatic stress disorder. There is an earlier instance of exposure to traumatic stress in that she was the person in the hospital after her father died who found him having students perform CPR on his dead body. So that was an early exposure to high traumatic stress, witnessing that incident, and based on her brother's description, that was something that changed her. When a person is exposed to numerous compounding stressors, their adrenaline system is changed. It alters your body. And things that might be an otherwise neutral situation, you tend to have a cascading adrenaline response to that. And I think that that ultimately, for her, as she succumbed to other instances of serious physical abuse from her partner, became post-traumatic stress disorder. I do think that that is a condition that is still existent even while she's in jail. It's something that she needs treatment for because those triggers are unmitigated, meaning that she hasn't really had the kind of therapy to address them and reduce her adrenaline and anxiety responses when she thinks of past instances of traumatic events that have happened to her. You can also respond to post-traumatic stress disorder clinically by using antidepressant therapy, and that would be something that could assist her ultimately in reducing symptoms if she had counseling and antidepressant therapy.
Now, Dr. Harper, I know that you had testified in trial that, in your opinion, she suffered as a battered spouse syndrome that is legally recognized in Florida, in the courts of Florida.
That's correct.
And I understand that that is tied to this intimate partner violence, which is maybe the same thing, but there's a complex mental health issue that ties into that. Can you speak on the complexity of that?
I mean, I think she just did, Owens. I think she just talked about the complexity.
Such as Sarah Boone and George Torres were involved in.
Certainly. So intimate partner violence is not a diagnosis. It's a pattern of events that occur between two partners in which the power dynamic is altered by the physical abuse or behaviors that are controlling in nature to the point that someone's safety is threatened. It's common for victims of that to have a complex mental health condition, often including depression, anxiety, and substance abuse problems. And what might be substance abuse to cope with the problem, like numbing oneself, will sometimes result in its own diagnosis. The pattern of intimate partner violence, I think we covered in the trial, but just in summary about that, there are phases in which at first the bonding of the two partners might be something positive. They've got something in common or have pleasurable time together. And then the secondary phase of that is when there is change in dynamic and some kind of traumatic event occurs, some instance of physical violence. And then there's a third phase in which it's like a honeymoon phase where they're trying to right the relationship. So in phase one, when they're having something pleasurable, the tone shifts. Phase two, there is some kind of incident. And phase three, there's a honeymoon phase. As that pertains to anxiety, I think that a person who suffers from intimate partner violence never stops experiencing that hypervigilance, waiting for the next instance of violence to occur. So even though they may look happy, they might be experiencing something positive, they've not really relaxed because their memory that that could or will occur again is still in their mind. So they haven't fully stopped experiencing intimate partner violence. It's just what phase of the process they're in.
Now, and Dr. Harper, it goes into more detail.
A number of you are saying this feels like testimony. It is. Dr. Harper is sworn in. The court is allowed to take evidence at sentencing. The purpose is just different. The defense is putting on evidence that they hope will mitigate the case so that the court will look at the lower term, which is 22 and a half years versus just an indeterminate life sentence. So they are allowed to put on evidence. And I think that, again, Owens is going to do what his client wants in this because it's not going to hurt. It's going to benefit his relationship with his client. It's court appropriate that they put on evidence at sentencing. The pen pal was wild to me too, but I imagine Sarah was like, I want these people to come in at sentencing. And for Owens, that's not a battle he needs to fight with his client if that's who she wants, because the court will just get to hear it and will do what they will with it. So that's why they are taking evidence. That's why the doctor is here stating, or restating a lot of her trial testimony. Sometimes with doctors, this is just in the report, and there is a sealed report here. It's not done in live testimony. It's done in a report, and then the court reviews that report. But here we are, and Fred is fretting.
The report, which I supplied to the court, which is a total of 11 pages, and I believe that's confidential document that's been filed.
That's what's been marked. I don't believe it's been filed in the court file.
Okay.
If it has, that's something if it needs to be, it's something we can address. I have reviewed it. It does reflect confidential and privileged information on the first page. I don't believe it's been filed in the court file unless you did it. Okay. It already has been? All right, appreciate it.
Under seal.
Okay.
It popped
Excellent.
up
Thank you,
under
sir.
seal today.
And Dr. Harper, you're aware that the defense has filed a defendant's motion for downward departure.
Yes.
And we've listed several factors under paragraph 3, the capacity of the defendant to appreciate the criminal nature of her actions and conform with the requirements of law were substantially impaired, that she requires specialized treatment for a mental disorder that is not related to substance use or addiction, although you agree that she does suffer from alcohol use disorder.
So she has an underlying mental health disorder, post-traumatic stress disorder, and I additionally diagnosed her with alcohol use disorder, which is separate.
But you agree she does require specialized treatment for a mental disorder that's not related to the substance abuse or addiction?
That's correct.
And you agree she's amenable for treatment?
Yes.
And you would agree that she acted under extreme duress in this unique homicide case?
Yes.
And you would agree that the uniqueness of the circumstances, the facts and circumstances surrounding the case, that the offense was committed in an unsophisticated manner?
Yes.
That it was isolated?
That's my understanding as well. That
He's going through what was in his mitigation filing and having the expert go through the things that he hopes are going to mitigate this. So that's why he's going through these very specific questions.
Then she had the charge where she was, both of them were charged at one time, and I think she had the strangulation allegation, the felony case that was ultimately dismissed when both of them were arrested.
she had a prior felony case. The facts are different, of course, than this particular case we're here today.
Dr. Harper, I believe that's all the questions I've got, unless you would like to say, if I've missed anything, of course.
It's in her report, I'm sure.
It's not in the report.
Yes.
Any questions?
Yes, may she take the stand so I can take the podium?
Yes, that's fine.
The prosecution has questions. The prosecution has questions. Oh boy. I'm only a little salty. The prosecutor didn't ask questions of the pen pal. Because God, I have questions.
Sir.
In pages 1 and 2 of your report, you go through the sources of your information, correct?
Yes.
And that would include 8 interviews that you had with her from the course of August of 2020 through September of 2024, correct?
There were 9 interviews, but 8 dates of service are listed.
You did the Miller Forensic Assessment of Symptoms Test, or MFAST.
That's right.
Inventory of Legal Knowledge, ILK.
That's right.
Clinician-administered PTSD Scale 5 examination.
Yes.
You consulted with her attorney.
Yes.
Videotaped interviews from this court case number of Sarah Boone, interview part 1 and 2, Abraham Moreno interview, Brandon Motes interview, Brian Boone interview, Juan Torres interview, and Melissa Sexton interview, correct?
Yes.
You reviewed the autopsy photos?
Yes.
You reviewed some of the digital forensic exhibits, including the Apple iPhone XS and a Samsung SMJ 327 T1 photographs from those 2 devices?
Yes.
You reviewed Bates stamped discovery pages 1 through 413.
That's correct.
The crime scene photos are photos of a scene taken on June 19th of 2020.
Yes.
Aspire Health records.
Yes.
And who do those pertain to?
Aspire Health records are for Sarah Boone.
Florida Hospital Medical Group records.
Yes.
And who do those records pertain to?
That is also for Sarah Boone.
And Aspire, is that a mental health treatment facility?
It has an emergency department record, but that would be the place where she was detained under the Baker Act.
And it is routine and common in the practice of forensic psychology or psychiatry to rely on the records of.
In Florida, Baker Act is the same as a California 5150 or a Massachusetts Section 12. It's an involuntary psych hold.
Other such practitioners.
As a source of information, sure.
You reviewed the deposition of Dr. Tanya Warner.
I did.
You reviewed the trial testimony of Sarah Boone, Brian Boone, Dr. Michael Brannon, Dr. Tanya Werner, correct?
Yes.
The jury verdict form dated 10/25/24.
Yes.
Witness list notice of filing amended.
Yes.
On this case. records of Jorge Torres or George Torres involving case numbers 2019 MM 5114, a 911 call in PDF, case 2019 MM 7193, case 2019 MM 7193, Torres Public Records, case 2019 MM 7193, Torres Photos, Central Florida Primary Care Records, Advent Health Orlando Medical Records, correct?
Yes.
And those latter records that I just mentioned, those for Mr. Torres and not Ms. Boone, correct?
That's right.
Then you reviewed Sarah Boone written correspondence, Sarah's listing of domestic violence incidents, Sarah's writings regarding missing days of work and Baker Act, and a 74-page life story.
That's right.
And then case 2018 CF 10573, public records and photos.
Yes.
And a telephone interview with Melissa Sexton, the property manager, which you conducted on October 1st, 2024.
Yes.
And a telephonic interview with Philip Paulson, the defendant's brother, on November 26, 2024.
Yes.
Where has Ms. Boone been housed and living since February of 2020?
At the Orange County Jail.
And does the Orange County Jail provide mental health services to inmates?
It does.
Well, there's the answer
And
to that.
you already testified you would routinely, as a forensic psychologist, review records kept of psychological or psychiatric treatment of a patient or a client, correct?
Yes.
In this particular case, have you reviewed any mental health records generated by the Orange County Jail for Ms. Boone?
No, I have not had the opportunity to do that.
So, for the last 58 months or so, if she was being seen by the mental health treatment staff at the jail, you have not reviewed those records?
That's correct.
And they are overseen at the jail, in the Orange County Jail, by a psychiatrist. Are you aware or not?
If the person's level of mental health intervention deems them eligible for psychiatry, then they will.
And any diagnosis or lack of diagnosis that they have had during the course of the last 58 months, you are unaware of because you did not review the records.
That's right.
I don't have any other questions.
Any redirect examination?
Interesting.
No, Judge.
All right, thank you.
One question. Dr. Harper, I didn't ask you to review those records, did I?
No.
Thank you.
Judge, I believe you said it at the very beginning that
Is
I
there
had
more?
submitted several letters on behalf of Ms. Boone, and she didn't hear that, but I wanted her to be made aware.
Yes, ma'am.
And that you don't actually read those letters into the record, but you did read them.
I have reviewed them. They're in my binder here.
She wants them read into the record? No, that's not how it works. So Owens is like, hey, Your Honor, can you please remind my client that you got all of the character letters? She's going to have a lot to say, isn't she?
How many do I have? Yes. Give me a second. I can tell you. I have.
She wants to know how many people said things about her.
I have 6 handwritten letters.
Mm-hmm.
First one is 1 page. Second one is 2 pages.
Your
Third
Honor,
one is 1 page.
what did they say?
Fourth one is 2 pages.
Did they?
Fifth one is 2 pages.
Did they tell you how great I was?
Sixth one is 2 pages. I have a typed letter from Diane Smith, the assistant chaplain. I have another typed letter from a Nicole Ray, a typed letter from a Stephanie L., a typed letter from Philip Paulson, a email from Lana Albert, 2 pages in length, and a 2-page email from a Danielle
From the
Parsons.
pen pal. The pen pal also submitted a letter.
Thank you.
Yes, sir.
Judge, I would like to call Sarah Boone.
You may proceed.
If you could take this.
Yes, please.
Well, whoop, there it is. Sarah Boone's going to take the stand and give her statement to the court on her own behalf. So let's go. Mm-hmm. Oh, boy.
Ms. Boone, you can be seated. You've been previously sworn. You may inquire, sir.
Just let her talk. Don't inquire. Sarah, what do you have to say? What do you want the court to know?
Sarah Boone.
Now, this is unlike a trial, so you're allowed to speak in a narrative form, as well as I understand you have taken some notes or written
Was she swallowing a yawn?
a letter that you want to read from, and then you want to speak.
Y'all called it.
After that.
Yes.
Why don't you go ahead and get started?
Yep, just go.
This is actually an edited version of.
An edited version? An edited version of what?
I had a lot to say. I've had a lot of time to think about
Oh, I bet you did.
things, and I didn't really know how to put it on paper, and I didn't know how much I could say or how little I should say. So what I have here is, like I said, an edited version. But I would like to read the more important parts that I feel that everyone should know that wasn't said in my actual trial. And on top of what I have on paper, I have, this is just the tip of the tip of the tip of the iceberg.
I bet it is.
So I wanted to read this, and then if I may, I would like to address everyone in my apology on top of my statement.
You may proceed, ma'am.
Just talk.
Kintu Sukuroi is a kind of Japanese ceramic style which means to repair with gold. In this tradition,
We're starting with kintsugi. We're starting with, for all of you that were on the members only stream before things, we're starting with kintsugi. Well, don't worry, members only will be back. We're starting with kintsugi. That, holy shit. I'm backing up because I don't even know how she pronounced that.
apology on top of my statement.
You may proceed, ma'am.
Kintu Sukuroi is a kind of Japanese ceramic style which means to repair with gold. In this tradition, when a ceramic piece breaks, an artisan will fuse the pieces back together again using liquid gold or gold dust lacquer. So rather than being covered up, the breaks become more obvious and a brilliant new piece of art emerges from the brokenness. It embraces flaws, weakness, and imperfections, and also teaches the essence of resilience. Every crack in a ceramic piece is a part of its history, and each piece becomes more beautiful because it has been broken. This is the wisdom of Kintu Sukuroi. In my wisdom and with all of my repairs, then, now, and ongoing, God is, has been, and will always be my artisan. All of my gold is forgiveness. This has held me together, made me shine brighter, and overcome the damage caused by George Torres, the Torres family, the justice system, Orange County Corrections Department, social media, scoundrel detectives, infamy, defamation, ongoing constitutional rights violations, second-degree murder, forced into being pro se. Just as gold is very
She's gonna let the judge have it? She's gonna let the judge have it? Oh, I'm sorry. I thought your attorney said you were remorseful. I'm sorry. The word he was looking for was wrathful, rageful. She's so fucking pissed.
very precious. Forgiveness is invaluable.
Okay. Well,
forgiveness is not an attempt to change or forget who, what, or how you've lived through to be so gold, but an act of grace, humility, and considerable self-compassion to be set free from sorrow.
Withholding forgiveness denies your brilliance and adds even greater grief and deeper heartache, irreparable cracks on top of the already that no one deserves, no matter the pain or disappointment, untruths or injustice. It doesn't matter, as the more broken you are, even though now different than before, you've become more outstanding and more extraordinary.
What's the over-under on her ending her statement with "Thank you for coming to my TED Talk"? What are our odds?
Above all, when you let go of blame, misunderstandings, excuses, give up your anger and cease from resentment, this is forgiven. And when you forgive, you heal. And when you heal, you move forward. My goal begins with George Torres, and every time he slapped me, kicked, punched, spit on, raped, stabbed, choked, laughed at, pushed, pulled, dragged, whipped, tripped, stole from, lied, terrorized, threatened, humiliated, forced, degraded, made me cry. Every time he tried to end me, defeat, or destroy. I forgive George for beating me senseless, for trying to sleep because I had to go to work or my son's field trip the next day, for ruining my deceased family's heirlooms, traditions, and keepsakes, my son's furniture, destroying the television we watched together, for wrecking our townhome by breaking windows, punching holes in the walls and doors, ramming his entire body into glass doors, kicking in my front and back door over and over and over, for breaking or removing the locks from all of the doors and sometimes the knobs altogether, so I had nowhere to feel safe, including the sacred space of my son's room where he beat me bloody on his bed. For terrorizing and threatening my blind and deaf dogs by leaving the gate open I built to keep them safe, telling me he hoped I'd find their bloated dead body in the pond or scrape their remains off of the pavement, for kicking them off of the bed and throwing across the room because they were trying to protect me.
So what you're saying is you're not
For
sorry.
threatening to make me unrecognizable to my son by breaking all of the bones in my face, like his brother Moses did to him after he kept seeing all of the bruises from George beating me, like all of the times their father beat their mother. For all of the drunken rages and fist fights with so many neighbors when wandering into their apartments during hunting expeditions after I had escaped.
So you're going what?
For drowning me in liquor
I
and
said
wine
what I
because
said.
I didn't want to drink, causing me to urinate on myself, then butting the end of the bottle in my face, giving me 2 black eyes and a bloody nose. For making me experience what it is to be sodomized. Threatening to kill my friends and the neighbors when they checked on me to make sure I was alive and in one piece. For threatening to burn down our townhome and set my car on fire because I got a job. For holding me hostage on weekends my son was supposed to come over by keeping my keys around his neck, my phone in his crotch, and a butcher knife stuck in the middle of the table as a warning not to ask anything or try to leave. For stabbing me in the leg and not letting me call 911 for an ambulance or seek help, where I nearly bled to death until I concocted a lie to save him from being arrested. For destroying my phone with a hammer because my son called. For me experiencing ever being arrested and after today, prison. For beating me almost blind, crushing my occipital lobe. For having me experience what it means to see stars like in the cartoons, where a character has a tall lump on their head. I had that too, and many times. For dragging me downstairs by my hair in the middle of the night just to sit next to him. For taking my car driving drunk with my debit card to buy more alcohol while I slept, even after I kindly explained the importance of my car to take my son to school foremost, me to work, and he to his batterers intervention classes and probation officer meetings, where I would be forced to sit for hours in the parking lot waiting for him. For causing me so much trauma and pain, mentally, physically, emotionally, I had to be hospitalized more than once. For destroying my reputation and integrity, for my M for murderer scarlet letter, not letting me feel safe to live, talk to other people, spend time with my son, have a job, friendships, simply go to the bathroom with the door closed, or go to sleep soundly or comfortably. I forgive George for lying, for him trying
You
in so
sound,
many ways, so many times,
full of
to end me with his
forgiveness.
terrifying love.
So full of forgiveness. In fact, that you just said it was his fault that you've been branded with the scarlet letter M. So she's doubling down on the I did what I did, I said what I said, and I meant what I meant. I don't think there's an apology in that.
I also forgive the Torres family, his mother and father foremost, also his two
don't think
ex-wives
they
and
give a
daughters,
shit
all for knowing
about
who
your
George
forgiveness.
was capable of and has done in the past, his history of violence and where he learned it, then to keep turning a blind eye when I would ask for help. All of his siblings, including Farrell Torres, who is now on his way to prison for stabbing the mother of their baby in the side of her head. For everyone who knew what George was doing to me, sometimes how and when, but allowed and enabled. I forgive them for caring too late. I hope they all ask themselves while quiet and comfortable in bed at night the uneasy question, what could I have done to stop this from happening to both of them? And after all the times Sarah tried to, by asking for help, from all of us and so many times.
Wow.
Another great contributor of my gold is social media, with its greed, insensitivity, deception, obvious exploitation, and advantageous gain from my criminal case as a whole, and for sentencing me by anticipation as a result of ignorance and hate, conjured and fabricated by the organized crime that is social media, which
Your social media pen pal bestie testified for you. Did she just call social media organized crime? There, she is big mad. She is gonna write books in prison.
night the uneasy
I had
question.
to back up a little bit.
What could I have done to stop this from happening to both of them? And after all the times Sarah tried to, by asking for help, from all of us and so many times. Another great contributor of my gold is social media, with its greed, insensitivity, deception, obvious exploitation, and advantageous gain from my criminal case as a whole, and for sentencing me by anticipation as a result of ignorance and hate, conjured and fabricated by the organized crime that is social media, which condemned me in the court of global public opinion since the beginning. My family law case is the new prey waiting to be picked apart and pillaged from me being made infamous by social media in my criminal case. It simply seems I cannot forgive and be forgiven and move forward. Social media has made me a pariah. It has caused great oppression and undeniable disadvantages, especially by broadcasting and manipulating my cases online. In my criminal...
Can you explain how the fuck your case was manipulated? I'm real curious. I'm real curious what the manipulation was, because a lot of the evidence was just videos of you or videos that you took.
case as a result, my opportunities to be given a fair, proper, and uninfluenced successful conclusion was heavily depleted and poisoned. I forgive them. Also, all of the media tycoons for not having a life of their own, trying so desperately to make themselves seem so right by making me appear so wrong.
Who are the media
Forgiveness
tycoons?
for prejudgment.
Who are you talking about? You put out an advertisement for your lawyers at a court filing. What is happening?
Ridiculous theatrics, lies, making and taking blood money from my and others' misfortunes, accidents, and catastrophes. It's all over their hands and their keyboards. And even after all that's been said and done, theorized, hypothesized, scrutinized, and blasphemed in my case, still no one
Someone just gave her a thesaurus and let her roll, right?
knows me.
No one knows you. Dude, we saw the videos you chose to take. She's so mad. We need like an audio clip of Lisa Rinna going, oof, you're so angry. She is so pissed.
Making and taking blood money from my and others' misfortunes, accidents, and catastrophes. It's all over their hands and their keyboards.
Wild.
And even after all that's been said and done, theorized, hypothesized, scrutinized, and blasphemed in my case, still no one knows me.
No one knows the real Sarah.
In the end, I forgive myself for not choosing my life sooner, for not being more brave, vigilant, bolder, and outspoken, stronger, mentally, physically, emotionally, and spiritually, for being hopeless, desperate, simple-minded, weak, and inexperienced.
I'm waiting for her to become Snoop Dogg and be like, I'd like to thank me, Because she's like, I forgive me. Now, self-forgiveness is really important. These are normally therapy conversations, but she just sounds angry.
I forgive myself for not realizing I was enduring a life of domestic violence and that the vicious cycle of never ends. I had nothing to compare to. I've never been hit by a man ever before in my life. I was raised hitting a woman was wrong and should never happen. No excuse. I forgive myself for not escaping permanently, for not fighting back sooner to save myself, my son, my dogs, home and car. Having 20/20 hindsight thinking of everything I could have done differently or better to avoid the outcome. I think about this every day since. Also, of all the good days we had together, for him at least, while I was constantly in hyperdrive, high alert, and paranoid, making sure I did everything right all the time. If not, the great possibility I would be ended as George threatened me with so many times before. I forgive myself for falling in love with a monster, and no matter how grotesque he may become, I still loved him, hoped, and forgave. I tried breaking the spell so he wouldn't be a monster anymore. I saw who he was inside. George made me then, now, and always love him for all of his cracks also.
He made me.
We made each other our own brilliant pieces of art from the cracks and
How many times has she said, he made me?
repairs. Unfortunately, not all cracks can be. In all of my forgiveness, George is my greatest lesson and will forever be a part of me. I think of him every day and still speak to him when alone on the rec yard. I ask his forgiveness and that he looks for me at the gates of heaven so I can tell him how sorry I am, endlessly, and that I never stopped loving him. In all of it and still.
I thought the capital
When
M
I first
murder
came
and
to jail,
heaven
I put my mat under my bed and cried
synonymous.
all day and all night for months, only falling asleep from being so exhausted with grief. I wrote him letters. I wrote his family and his daughters, apologizing for asking for their forgiveness. But due to fear that my life or sons would be jeopardized, I did not send. I am sorry. I cannot begin to fathom any of their grief and sadness.
I can't.
Please forgive me.
I can't fathom what them sitting through this is like for them. But then again, we saw the text messages, and I think that they know that this is exactly what was going to happen.
Almost everything reminds me of him. Seeing my stab wound, especially
forgiveness is to be given,
every
not
day,
asked
especially.
for.
It truly reminds me that all I really did live through. George haunts me. He is everywhere. I believe because I do still love him, think of him, and miss his laugh the most. In my heart, I know he is with me and understands that this tragedy was not intentional. I hope everyone can, his family foremost.
Not intentional.
I didn't mean for this to happen. Please wholeheartedly know that, and always, I would never. Forgive me, George. Forgive me, Torres family. Forgive me, Judge Cranick. To the entire planet, please forgive me. I graciously and humbly ask for consideration for forgiveness to be extended instead of judgment.
Ma'am, if you have to tell us that it's gracious and humble, your tone belies you a bit. That sounded more like a demand.
Reconciliation and restoration for all of us to move forward. My apology is profuse and ceaseless. Allow me, please, to brush off the muck, wipe the blood off of my face, and fix the cuts in my skin.
What about the blood on
I
your
ask for
hands?
understanding in what really happened and for how long. For second chances, repentance, and redemption to advocate for all domestic violence survivors, to help them overcome, heal, and still hope, always, to make their voices heard, to confidently walk with all of their scars on the outside and the inside, to help them not ever become a casualty of domestic violence as so many others, to stop the abuse and maltreatment before it's too late. There is
Like
always
George?
hope, and you can survive. In my soft-spoken conclusion, I ask this. Would I be the...
In my soft-spoken conclusion, I ask this. It sounds like she is reading a script for herself, and she's like, pan to stage left, soft-spoken. In my soft-spoken conclusion, ma'am, I think this case is a reminder to everyone how difficult it is to leave an abusive relationship. but I don't think a lot of people identify with you, and where you're at, because we saw all the videos is the thing. But I do think the case is a reminder about how hard it is to leave and why it is imperative. But let's get back to her narrating her soft-spoken conclusion.
Abuse and maltreatment before it's too late. There is always hope, and you can survive. In my soft-spoken conclusion, I ask this: would I be the darling mother, celebrated woman of the year, if it were I who died? How many daughters, mothers, sisters, aunts, grandmothers, nieces, and friends have been because they did? I am a survivor. Learn to do good, seek justice, rebuke oppressors, defend the fatherless, plead for the widow. Isaiah 1:17, all-encompassing, protect the abused.
Ms. Boone, is that the end of your written statement?
No, she's not fucking done.
Now, gathering your thoughts, did you want to make an oral statement?
She sure does.
I do.
All right, would you do that now?
Yes, please. My statement, my verbal statement, is primarily to the Torres family, to the judge, to his daughters.
I don't know if they want to hear from you after that, but they
I
don't
know
really have a
you all
choice.
know who I really am, and that I did care for George, and that I do still love George.
There's an internal inconsistency in your statements, because earlier you said no one knows me. So as we're getting into that, I don't know if she's going to apologize.
I know you know that we had very many good days, and I take offense to the statement of being said that this is just for a moment. Right now with me here in the courtroom in front of you all, this is just for a moment. But the moments before that, in order for me to be here,
It's not
is
an apology.
endless. It's everlasting. The scars that I have on the inside, my outside scars have healed, except for my stab wound. But this has changed me as a person to see things differently and to understand things differently and to not be weak and just try to protect yourself, and forever, regardless of the time that I may receive from today, I forever will have this experience. I forever will have George Torres with me in my heart, in my mind,
This experience?
my body, and my soul. As he and I used to say that we were one soul split into two bodies. This is not just for a moment. It may be for everyone in this courtroom, but when I leave, this is forever. When you all leave, that this is forever. This is forever for everyone here and those who it matters to most. I am one of those who will experience this forever. I'm sorry. Words do not define my shame, and I don't know what else it is that I can say and convey to the Torres family how this happened.
Well, you did blame them earlier.
The ifs and whys and how
So-
really don't matter. It happened, and I'm sorry. Words cannot describe. And I hope that everyone can forgive me, the Torres family most of all, and his daughters, because I know what he meant to them. And I don't think that anybody ever understood what he meant to me and I to him. And I ask for forgiveness.
You've asked a couple times for forgiveness.
Ms. Boone, I have just one or two questions, if you don't mind.
Oh God, don't. Oh, okay, Owens.
Speak on it if you want, or not.
She's
This
like, why are you talking to
It's a
me?
unique case, and one of the reasons it's so unique is that you were in jail for 4.5 years prior to your trial. And I understand that when you were brought up as a child, that you did have some spirituality in your family? Some church, some religion.
Always.
But I understand that you got away from that. Did you have a chance during the 4.5 years to look back at your spirituality?
Absolutely. You know, everyone supposes that this is one of the worst experiences of my life, and it's actually been one of my greatest. If I were not beaten to death, I was going to work myself to death on the outside, and I never had time to get back into my Bible and to pray and to be with the Lord. And I, being here incarcerated, have had time, of course, to get closer to God, to reacquaint myself to Him and realize what it's all about. This is all temporary. And when I say temporary, I don't mean by being set free in jail or from prison or wherever else. It means being set free and temporary, meaning that you work for something higher, you work for God, that you strive for your crown to be placed upon your head by Jesus Christ by being said, "You have done well, my good and faithful servant." I've always tried to be a good and faithful servant. I was just a servant as opposed to doing all that I can when my family were alive and I was going through everything up to this point. I've become so much more closer to the Lord, and it's made me such a better person, and I hope that I am an example going forward of the Lord's light and can draw many people to me because of it.
Just not on social media.
Any follow-up, State?
Organized crime.
No, I assumed that was the final word.
The state was like, are we
Thank you.
done?
She can return back to council's table.
Anything further,
Anything
state?
else from your side of the ledger, Mr. Owens?
No more witnesses, Judge, just arguments.
Okay. Anything else in rebuttal, or just proceed to argument, State?
Just argument.
Okay. All right. Once Ms. Booth's seated, you can proceed with your argument.
And now we're
Either
proceeding
Mr. J or Mr.
to
Cacciatore.
argument for sentencing. Remember, Sarah Boone's been convicted of second-degree murder. The sentencing scheme allows for a minimum of
You may proceed,
22 and a half years and a maximum of
Your Honor,
non-determinative life, not life without the possibility of parole. She would have the possibility of parole somewhere down the road. So now we're going to hear the state argue. I imagine what they're going to ask for is life. We'll see what they have to say.
I'm going to start my argument by what I anticipate Mr. Owens will bring up in his presentation regarding the plea offer in this case. That she was offered the resolution in this case of 15 years in the Department of Corrections to begin with. I think it's important, though, that
That was for her to accept
the entire
responsibility.
circumstance of that plea offer is put forward. And there's something very critical to that. It's
Ooh,
not
tell us the
just
tea.
15 years in the Department of Corrections. It's 15 years in the Department of Corrections, but it's predicated on something. And the consideration that it's predicated on is the defendant coming to court and accepting responsibility for her actions.
Yep.
For her coming to court and saying, I am responsible for George Torres's death, and I accept the punishment that comes with it. That consideration
No,
was
she's just
never
saying it was
given
unintentional.
in this case. And because that consideration was never given in this case, the offer of 15 years in no way represents what this case is worth, or what George Torres's life is worth. That is an offer predicated on a particular
Acceptance of responsibility.
a circumstance of a first-time defendant accepting responsibility and giving every benefit of the doubt in coming to court and saying that they are ready to be punished. Those conditions were never met. So then we turn to this case, and we turn to this crime, and we turn to the actions of the defendant of taking the law into her own hands and murdering George Torres She has never shown remorse for that. She didn't show remorse for that here today.
Nope.
She again painted herself as the victim.
Yep.
She's the victim of George Torres. She recounted the litany of
Complaints.
evil deeds and mistreatments that he perpetrated upon her. She's the victim of George Torres' family.
She said that.
She's the victim of police. She's the victim of social media.
And this
it's
court?
all about Sarah Boone. Everything's about Sarah Boone, about how she is the victim.
He's saying the quiet part.
And Sarah Boone sentenced every one of George Torres' loved ones to a life sentence. Just like she sentenced George Torres when he was in that suitcase. George Torres lived out his last nightmarish circumstance in that suitcase, begging to be let out for several minutes, which undercuts any argument that this was somehow unsophisticated. There was ample time and opportunity over and over for her to do something different, but she went forward with taking the law into her own hands and ensuring that George Torres was never getting out of there, while she went up to bed and went to sleep for hours on end. She can't say that she was in duress for the same reason. She was in such duress of George Torres that she goes upstairs and goes to sleep for 11 hours. Your Honor, there's been nothing from the testimony of Dr. Harper either that establishes any type of diagnosis that would give this court a basis to downward depart. Dr. Harper has put blinders on to the fact that she has been incarcerated for 58 months. 58 months with the opportunity to receive mental health treatment.
Oh.
And the expert witness is absolutely incurious about what any of those records or diagnosis or anything that would have been there would have said. There is no valid basis for a downward departure in this case. She deserves a life sentence. Thank you.
And
Mr. Owens, response?
The court. Did he just knock over his water? He sure did. The court will have the pre-sentencing report. It's sealed. But the court will have the pre-sentencing report that shows if she has been seeking that type of treatment in custody. All right, Mr. Owens.
Just credit. First off, I want to thank you for taking the time to hear our side, hear the witnesses. And,
He's always heard your side.
Letters on Sarah Boone's behalf. You know, we've all been here for this trial. We've all been here for other trials. We've all got some age on us. We've all got some life experience on us. And this is a unique case. This was a unique homicide. It was a unique death. And as we all know, a lot of these cases are not black and white. They're shades of gray. And these crimes don't occur in a vacuum. That there's generally a history, especially involving a domestic couple, a history that comes into play that must be explored. And a lot of what Sarah Boone testified to here today probably happened behind closed doors. And we all know that many times we do not know what happens behind closed doors between a man and a woman in their home.
However, we've seen a lot of the body cam footage. And you know how else we know what happened behind closed doors in their house? She recorded quite a lot of it.
Unless there is some reason for the neighbors or law enforcement or somebody else to get involved. And that happened in this case. And so gradually over time, as this event occurred, there was an investigation, and it was learned that there was a history of domestic violence involving these two parties.
That's true.
And what we learned was that physically there was violence, and there were photographs to establish that, as were introduced in the trial. And then there was testimony from experts, not only the defense expert, Dr. Harper, that Sarah Boone was the victim, and she was a victim of intimate partner violence, but coupled with the fact that the state's expert testified on the stand at the trial that Sarah Boone was a victim of intimate partner violence, that she suffered from this domestic or this battered spouse syndrome as the hands of George Torres.
He precariously didn't mention...
There's two sides to it.
Video.
And in a domestic violence situation like that, 95% of the women get out of that relationship. When violence starts to occur, they've either been raised a certain way, they have a certain self-esteem about themselves, where they refuse to put up with it, knowing that it's wrong, knowing that they can do better. But there is a small percentage throughout the country that, for whatever reason, mental health issues, addiction issues, whatever it is, it's complex. Financial reasons, children are involved, whatever. If you do any studying on it, there are circumstances where there is a group of women, predominantly women, it can happen to men, but majority of the time it's a woman that gets caught in this cycle.
She did not have kids with her victim. She was not financially dependent on her victim. She was not dependent on her victim for housing, for transportation, for access to the internet, for a phone. She was not the one who was dependent here. You guys know it. I know it. The court knows it. He is doing his job. There are times it is tough to sit and listen to it, but the court knows, and I'm sure the court is sitting there thinking the same thing we're all thinking. And yes, we are a little behind on time, so of live court, because my flabbers were gassed at about 16 times, and we had to pause and talk about it and say, hello, caller. So if anyone comes in and shares the results, well, we kind of know what they were going to be. We talked about them at the beginning, but it will be deleted because we're going through it together. We're the law nerds. So thank you for no spoilers, chat. But I think I kind of spoiled it at the beginning and told you what I thought the judge was going to do anyway. I just want to hear what the judge is going to say.
Of what we term as intimate partner violence. And court heard the testimony about the cycle that occurs. It's over a period of time and it repeats itself, and you go through these phases. And a lot of times the victim's not a great historian at trying to articulate it. She tried to do it here today. And I think on Sarah Boone's behalf, she is a unique individual. She's got the personality that she's got.
Accurate.
I don't know. You heard from Dr. Harper that a lot of that was formulated based on the way her mother.
She's got the personality that she's got.
Did not bond with her. The way that her father was the way that he was. The fact that she lost several relatives at a young age, and the trauma that can result We heard from Dr. Harper that she did suffer from post-traumatic stress as it relates to that trauma in early childhood, and then again as it relates to the events that occurred between Mr. Torres and her. So it's complicated, Judge. It's complicated. But the jury has spoken.
Yes, they have.
Sarah Boone was entitled under Florida law to present that defense, and she did.
And they didn't believe her.
That testimony was allowed to be presented. She was allowed to testify.
And she did.
But the jury spoke.
Yes, they did.
And so here we are today.
Swiftly.
With you in a position to decide what is justice.
I mean,
for Sarah Boone.
His option is really like life.
And I don't know you that much other than our time together, but from what I know you try to do the right thing.
He's incredibly patient.
And that's what we're asking the court to do. To have some discernment, to have some understanding of the unique situation that Sarah Boone found herself in.
I think you and the judge are going to see this
And
differently,
quite frankly,
Owens.
Judge, this all didn't occur behind closed doors. A lot of this was in the public eye.
There's internally inconsistent statements there.
Mr. Torres had, I believe, 3 criminal cases before the courts of this county in which Sarah Boone was a victim. Mr. Torres was the accused. Those cases were dismissed. We know from the history of this domestic violence field that that's normal, that Sarah Boone every time either tried to bond him out or tried to get the case dismissed. At some point, somebody has to stop. Somebody has to say, wait. What's going on here? This keeps repeating. It's going to get worse. Something's going to happen. The system failed, Sarah Boone. I'd ask for you to consider that. The circumstances surrounding that failure and what led us here today. I've asked the court to consider a downward departure.
I thought he was done.
I believe you've gotten a copy of the score sheet, please.
Not since before trial.
Okay.
Is the score sheet stipulated to?
Yes, sir.
All right, you may approach. Thank you. Yes, sir.
Judge, I was provided that here today, and I believe, I can't remember the total number of months that it involves, but divided by 12, I think it's 20 months. 20.6 is the low end of the guidelines or something about.
It's 246.0 months based on the score sheet.
I did the calculation, but I believe that the low end is 20 years, 20.6 years state prison, I believe is the low end.
22.5.
20.5. Yes, sir.
As the court knows, I believe it's on page 3. There are some aggravators that the court can consider in opposing the sentence, and then there are a list of mitigators that the court can consider in downward departing, meaning going lesser than the low end of the guidelines. And in the defendant's motion for downward departure, we mentioned, and I had Dr. Harper testify about 2 or 3 of the grounds, and the court needs to only find 1 to go below the guidelines. The capacity of the defendant to appreciate the criminal nature of her actions and to conform said actions to the requirements of the law were substantially impaired.
Pick a different one.
Judge, I don't have to reiterate the facts and circumstances surrounding this event. You were here, you heard the testimony, you heard the circumstances surrounding what happened and how it happened.
She doesn't appreciate the criminality of it. She got up there and railed at everybody and said, y'all should have done something. I did what I did. That's not her appreciating the criminality. She said over and over, it was unintentional.
I would ask that you consider that as a mitigator.
Okay. Owens.
2D, the defendant requires specialized treatment for a mental disorder that is not related to substance abuse or addiction and is amenable to treatment. think it's fair to say here that we know that Sarah suffers from some mental health issues, objective mental health issues that have been opined by Dr. Harper and Dr. Werner. And you heard Dr. Harper testify about the post-traumatic stress disorder that she suffers from as it relates to this event, as it relates to her trauma that occurred in childhood. I think we heard from Dr. Werner. Dr. Werner testified that she suffered from the alcohol abuse
same thing she said at
disorder,
trial.
as did Dr. Harper, but Dr. Werner also mentioned that she was not for sure about the anxiety disorder, whether it occurred prior to or because she was in the jail for the 4.5 years. However, she does require specialized treatment for the mental disorder, and she is amenable for treatment. And then third, the defendant acted under extreme duress, I think based on Sarah Boone's mindset as she testified to her today, and then you heard from the experts at the trial that when you get that anxious about what happens, Sarah testified about they would have good days where there would be no drinking or very little drinking, and then there would be other days where there was heavy
Sarah said he had good
drinking.
days.
And generally, when George Torres got highly intoxicated is when potentially
That's what she
things
said
could get
today.
violent. And that she was constantly anxious about each day that she was with him. She loved him. Obviously, being in a cycle like that where you love someone but can't leave them. For whatever reason, George Torres couldn't leave Sarah Boone, and Sarah Boone couldn't leave George Torres, and it was a vicious cycle. But we believe that she qualifies under that it was under extreme duress at the time of this event. And lastly, the defense was committed in an unsophisticated manner, which was an isolated incident. Now, isolated, we know, Judge, that she had one prior event in which both of them were arrested. You heard her testimony
She did testify
that it was
about
during an event. They ended up downstairs next to the washer and dryer, and that she was on the bottom, and she had used her hands to try to get him off, and she had tried to choke him, and there were some marks on him. And she was arrested for I think felony domestic violence battery, as well as he was arrested. I think a few days later, both of those charges were dismissed against either party. But she has no criminal conviction record. She has never been convicted of a crime other than that event. Now, I
Until
think that can be
now.
distinguished. So we believe that it was an unsophisticated manner. Obviously, the uniqueness of this event is unsophisticated. Anybody that would calculate that they were going to murder somebody by putting them in a suitcase and letting them spend the night, and the next morning not try to dispose of the body, not try to put the suitcase in a car and go dump the body, not try to dispose of the bat, do something. She did nothing. No attempts to tamper with evidence. No attempts after the fact to uncover any conduct whatsoever. No attempts to delete the videos from her phone. Here's my phone. Voluntarily given that information. I think that goes to the unsophisticated manner of unintentional death that occurred. I remember the first time I saw the suitcase video. And I know people have different
trip
opinions.
down memory lane then?
Tony Henderson, my colleague, had a different opinion when he saw it. But I remember the first time I saw the video, and I heard what she was saying to him.
The judge's
And
face.
he was saying, "Hey, Sarah, let me out. I can't breathe." Worst of
That's
the
not exactly how he said it.
And the way that she was talking to him, and the statements that she gave to him, in my mind, what has he done to her? What has he done to her? Any loved one you see in a situation like that is going to run and let them out. So my thought was, obviously, they were both drinking. But what has he done to her? And I think it's telling about what she'd endured. So it's not a clear-cut case, Judge.
Okay.
It's not black and white. There is some gray. And it's up to you to decide what's appropriate based on the court's, based on the jury's decision. But I would ask you to temper whatever justice that you think is appropriate with some mercy. And consider the fact that the state was willing to offer 15 years on a manslaughter.
Yeah, the state knew you were going to
It's
say
a
that.
lesser included offense, based on the facts and circumstances that they were aware of
No,
prior to this trial.
based on her accepting responsibility.
Any rebuttal by the state?
Good job, state. I want to hear what the judge has to say.
Court has had the opportunity to review the
And we will hear some of the judge's thoughts here before he pronounces sentencing. I'm curious to see how many of Judge K's thoughts that he will share. We've heard some judges let the defendant have it, and we've heard some judges that are fairly restrained. So let's get to Judge K's thoughts on this case and sentencing. Let's go, Judge K.
The evidence and testimony that was presented at trial, the victim impact statements presented here today, the statements of character witnesses, both orally and in writing, Dr. Harper's report and testimony, the defendant's testimony, pre-sentencing investigation, the arguments of the state and the arguments of the defense. Court pronounces sentence as follows. Ms. Boone, court sentences you to life in the Department of Corrections with credit time served that Madam Clerk will provide to you momentarily.
Right.
There are also court costs and costs of prosecution, which Madam Clerk will give you the totals of momentarily. Due to the court levying a life sentence, the court is inclined to liquidate those to a civil judgment unless I hear opposition from the state.
No, I'm sure you won't.
All right. Madam Clerk, if you could please give us the credit time served and the court costs, please.
Is he not going to say
9
anything?
months and 8 days, and the court costs are $418, a state prosecution fee of $100, a dirt fee of $50, and a PD. Oh, excuse me, you're not supervised.
I'm right.
So the total would come up to 600 and
So $600 and something dollars.
$618.
I wonder if he will say
Ma'am, the
something.
court
We'll
costs
see.
and costs of prosecution are $618.
That's
Those will be
low.
liquidated to a civil judgment. You will be given credit time served of 4 years, 9 months, and 8 days. You will have 30 days from today to appeal the judgment and sentence in writing. If you cannot afford an attorney, one will be provided to you. I'm going to have the courtroom deputy provide you the paperwork. Because you've been incarcerated for the last 58 some odd months, the court is going to declare that you are indigent in this matter. I cannot appoint the public defender to represent you as they are conflicted out. Similarly, I cannot appoint the regional conflict counsel to represent you for the same reasons. The clerk will appoint an attorney from the conflict wheel who specializes in appellate litigation. And again, you'll have 30 days from today to appeal that judgment and sentence in writing. Do you have any questions for me? You will now be remanded into the custody of the Orange County
I
Jail
really
to
wanted
transfer
to
you
hear
to the
what he had
Department of
to say.
Corrections, and I wish you the best of luck. State, anything further?
No, Your Honor.
Defense, anything further? All right. Thank you all very much.
Judge K.
Court's off the record.
All right. And that's it. The judge pronounced sentence with no further thoughts or opinions and is off the record. I'm going to leave court up for a minute and then we'll answer some questions, but that's it. I think her attorney probably prepared her for the fact that this was going to be a life sentence. For those of you asking, this is not a life this is not an LWOP sentence. It's not life without the possibility of parole. So she will be at some point in the future eligible for parole. But it's going to be 20 odd years before she would come up for that eligibility for parole. So yes, down the road, she will be eligible for parole, but that doesn't mean she'll necessarily get paroled. So let's see what, or if the court feed shows anyone in state. Some of you are saying Florida doesn't have parole for life. So if it's life without parole, then it is just life. So no parole in Florida. A lot of you are saying Florida doesn't have parole. All right. So then life is LWOP versus other states where life is 25 to life and or 15 to life and or 20 to life. So life, no parole. All right. Thank you guys. On a second degree, really? That's interesting. I need to take a look at Florida, because I haven't seen states that have LWOP on second-degree murder. But if any state was going to do it, Florida is high on the list of the fuck around and find out states where you are going to find out. So if life is life, then that is it. But what is she saying? I'm going to rewind real quick because it looks like she is saying something to, I don't know to who. So I'm going to turn the volume back up. This is why I always keep an eye on what's happening at the after court walking arounds. Oh no.
She's on her way.
Okay. Can you just give me a heads up when they get her here?
Yeah, I got you.
I gotta go down and see her real quick.
And they've got a bunch of paperwork they're going to have to do because she's going to get transferred. But she'll probably go back to jail before she's transferred, but she's going to get transferred. And that's it. They're going over, I imagine, her appellate counsel and what have you. I'm going to need to do a little bit of research on Florida because life in Florida, no parole is wild. So I'm going to need to look. All right. So they're going to give her all of her information for her appellate counsel because we know Owens is out. Like, we know Owens is out. He said that in the last interview. I like Owens' coat, though. I mean, is it cold in Florida at the moment? Or is it just cold in the courthouse? I don't know. We'll have to ask. So, with all of that, sentenced to life and done. The Floridians are like, no, it's freezing here. Fair enough. You guys are like, Florida is having some cold. It's fair. It's cold in Tennessee today too. It is cold in Tennessee. So, but also cold is relative. It is cold. So, as after she gets on out of court, we'll do a summary and then we'll answer some questions. Chat, it's good to see you. I know for those of you that are like north, you're just like laughing. Like Buffalo is like, have you been watching football? It's just been fucking snowing like nothing you've ever seen. But it's all relative. I mean, when it feels cold, it feels cold, right? So, it's wild to me. All of y'all from Florida are like, dude, Florida has no parole. Life is life. Given that, it's wild to me to take this to trial, knowing that if you're convicted, you're probably getting life. That's wild. But different jurisdictions are different, which is why I always say different jurisdictions are different. But thank you guys. For all of you that have shared that Florida abolished parole in 1983. Yep. So it looks like Florida only has probation or they have life, which is very different than California. But I mean, Emily, have you ever said anything less astute than California and Florida are quite different? No, never anything less astute. So, life. And that is what it is. So, in most states, a indeterminate life sentence, you are eligible for parole at some point. And then in California, they differentiate between indeterminate life, which is generally you're 25 to life, and then sometime after 25, you're eligible for parole, and life without the possibility of parole. So those two things are different. But again, different jurisdictions have very different rules. And if parole is not an option, then life is just until the end of your natural life. Though there was a really interesting case where somebody had like a heart attack or something in custody and was trying to argue that their natural life had ended, and then should when they were revived should be done with their sentence, and that is not. The courts did not find it to be well taken. Thank you, Miguelina. I will go there once we are out of court, because it looks like Owens gave a brief statement outside of the courthouse. So we'll go to that next, but I'm going to put this on 1.25 and answer some questions. We'll do a summary at the end of this, but you never know what happens in court. So we're going to leave court up and running. I just sped it up a bit. So let's see. Patty said, how can she pay costs? They converted it to civil judgment because she's not going to get out of custody. So she's not going to pay costs. Court costs in California are in the thousands and thousands and thousands. So when he's like, your court costs are like $600, I was like, wait, what? That is what? This is some of the lowest court costs I think I've ever seen. So it's interesting to me that in their sentencing scheme, including a second-degree murder, that life no parole is on the table. But there we go. So Cat Mom said, what is a civil judgment in this case? The court fees and costs were converted to civil judgment, which means she's not going to pay them. They're not going to stay on her books. It just gets converted to a civil judgment. Like, you had this money and you owe it and you're not going to pay it. Some of you are asking, why did she mention her custody case? I don't know why she mentioned her custody case. I can guess, but this is Emily's speculation. So with all of the salt taken, I would imagine people are digging into her child custody case or her family law case because of the interest in this case. So that's what I would guess. Let's see. I'm going to try to grab this question. There's a lot of us in the chat, so it jumps. Griffin Artworks said, what is the length of her original plea deal? She was offered 15 years on a lesser included. So it's wild. I mean, after seeing some of her court filings, after seeing her in court and what have you, and seeing her statements, I'm not surprised. I'm not surprised that she didn't take the plea deal, given everything we've seen. But so that. But no, I'm not. I mean, a lot of family law stuff should be sealed in the first place, but we'll see. I wouldn't be surprised by that. All right, I'm gonna answer some questions. We'll see if she gets let out of court at some point, but I mean, a lot of paperwork's gonna happen. That's what happens next. Alan said, I wanted to thank you for keeping me company from being in a recovery program to reaching 3 years sober and getting a job as a peer support specialist. Alan, congratulations. You are in good company. There are lots and lots of sober law nerds here, and congratulations on 3 years and the job, because now you can help others do the same. So let us continue on. AK said, I turned 36 this week. I'd like a motion for the law nerds cheers if EDB sees this. Yes, with whatever you would like to cheers with. Watching EDB got me real good at cross-examining Karens at work and saving open-ended questions for customers we like. See, you learn a lot of skills here. Lots of skills to be learned here in court, because yes, sometimes you need to just get to those close-ended questions to try to shut down the soliloquy that might uncork when that soliloquy is not needed. So, all right, she's getting let out of court. Hazen said, the audacity, law nerds need a code green, please. We were so red we didn't even get to green, but I'll grant your motion for audacity now, because I don't know. With Sarah Boone, I don't know if it's audacity or if it's her brain. I don't know if she's trying for the audacity. I think it just is very much the way she sees the world, if that makes sense. So I saw Rex asked if the members only is back up after much zhuzhing. It will be back up after this stream is done. But yes, it is. We have finally gotten the all clear, so it will be back up. But it took a minute because even though I played a music video on mute, it still got big mad about the video. So different parts of it had to be cut out. So which again, you know, on Members Only Live, we talk about music a lot. So things sometimes can happen with that. All right, I'm gonna go find Owens' interview real quick. Let's see, from outside of court, and I am grabbing this from Recovery Addicts Trial TV. So that's where I'm grabbing this from. Let's go see what Owens has to say after court, and then we'll do a summary, and then we'll finish questions. Sound good? Sounds like a plan, Leonards? All right, let's roll, shall we? Hopefully the sound is hearable. All right, I had turned that way down, so hopefully you guys could hear that too. All right, Owens, let's see what you have to say, other than I'm not the appellate attorney. I imagine that's part of what he's going to say.
Were made. We had 2 experts.
A lot of statements were made. That's accurate. A lot happened in that court today. Like a lot happened. A lot happened.
Good, how are you? Very dissatisfied, very unhappy about that result based on the testimony that came out from the 2 experts.
You're surprised? You're surprised? You're surprised? Well, no, he didn't say surprised. He said unhappy.
Are you?
Fair enough.
Very dissatisfied, very unhappy about that result based on the testimony that came out from the 2 experts, as well as Sarah's testimony about the abuse that she suffered. Obviously, I don't believe she was lying about that. I think we had a history of it with photographs, with arrests that were made. We had 2 experts, not only the defense expert, but also the state's expert, saying that she suffered from intimate partner violence. I think that is at least a minimum, a mitigator in something like this. I understand the jury's decision. We respect the jury's decision. But the testimony, the photographs, the evidence was clear that she was abused.
And this is why I wanted to hear from the judge to say, on that night, Sarah could have left. On that night, I wanted to hear the judge talk about that, because he's like, well, this happened, and then this happened, and this other thing happened. Yes, but given all of that, how was George a threat to her from inside the suitcase? And that's where it doesn't match with what the law requires.
And no, I'm not happy with the life sentence.
Sarah Boone didn't have much of a reaction as far as what we could see inside the courtroom after learning she had a life sentence. How did you talk to her after? How is she feeling?
Well, she did say something to me to the effect that, can you believe it? I got life. And I said,
yep, I can.
No. So, you know, I think she was poker faced. I think maybe that's what you're referring to, but I think she was not expecting life. Neither was I.
Mr. Owens.
Did he not prepare her for the very real possibility that when she was convicted, the most probable outcome was a life sentence? The most probable outcome was always a life sentence. After, especially, the videos that played in the rebuttal of the trial.
No? Jules with Top Mark Media. Can you tell me, did you prepare her for what might happen today? Was she prepared for this?
Yes.
Okay,
Yes,
then.
she was.
Well, that answers
You know,
the question.
we talked
Good job,
about
Jules
the
from Talk
minimums.
Mark
We
Media.
talked about the maximums. She was aware. The court had told her what the minimums and maximum were before trial, so she knew.
Yeah, the judge told her
what they were. She understood the judge had the power to downward depart and give lesser than the low end of the guidelines. He did not do that.
No, he did not.
So, you know, that was his decision. He's the judge. He's the trial judge. He ultimately had to make the call. The jury made their call. It was the judge's time to pass sentence, and that's what he gave. You know, I respect Judge Kranick. I like him a lot. I disagree with that sentence.
Can you talk about the next steps for Sarah?
Well, she's got 30 days to file an appeal.
She'll do that.
Usually, these appeals are handled by the public defender's office, who has maybe 3 or 4 lawyers within the office, and
Yes,
that's all
that's
they
not gonna
do is
happen.
appeals. But in this case, Judge Kranick has said, I've already found that there's a conflict with the public defender's office.
Right.
I've already found that there's a conflict with the alternative public defender's office called Regional Conflict Counsel. So there must be a list of appellate lawyers
said
that
there
do
was
appellate criminal work in the private bar, and the clerk will pick.
Owens, he said that. He said they were going to go through their extended circle of conflict-free appellate counsel. But it is a problem because so many of the lawyers who had been on her case are no longer on the case. So they aren't going to be the appellate counsel for her, and she'll get appointed appellate counsel.
Whoever is next on the list will be her lawyer.
And again, you won't be representing her.
No, he's not going to represent her for appellate work.
No, I mean, never say never. You know, if the case gets reversed on appeal and she's entitled to another trial, I'm not going to say I'll never represent her a second time, but I'm definitely not doing the appeal. And we'll see. I do believe there are 3 or 4 good appellate issues. We'll see what the appellate courts say. That usually takes, I think, about 1.5 to 2 years for them to come back. So she'll be with the Department of Corrections wherever they send her for the next couple of years.
And I apologize for this, but my camera glitched as we were starting. Your reaction to the verdict?
Disappointed.
Well, disappointed with that. I thought because she did suffer from battered spouse syndrome, and that was elicited from the state's expert as well as the defense expert, as well as the testimony from Sarah Boone, as well as the photographs and the evidence, the arrest of Mr. Torres prior, that she was the victim of battered spouse. I thought the court should consider that. It was within his discretion to give her life. I just strongly disagree with that result.
Thank you.
Thank you very much, Mr. Owens.
If you believe that Sarah was more apologetic in her statements today, the judge may have given her a lighter sentence.
No. I don't think it really mattered at this point what Sarah said. I think the nature of the crime, the way the crime was committed, and the videos shown at trial, especially in the rebuttal case. I think without the videos in the rebuttal case, maybe it's a closer question. If you don't have the videos in the rebuttal case and you don't have the battered spouse defense allowing those in, then I'm going to let Owens finish. I think you have someone who was intoxicated and videotaped just the suitcase video, and then the case looks a little different. When you get to the videos in the rebuttal, everything changes. Everything in this case changes with the rebuttal. And so I think that with that, it didn't really matter what Sarah said today all that much, because the judge was not going to give her not a life sentence after the trial. So, but you know, at least she sees herself as beautifully broken. So there's that. And she wanted to run that defense. That was her choice.
No. Sarah seemed very upbeat when she walked in. Was that truly how she felt, or was that like a stiff upper lip kind of thing?
She was so pissed. Sarah's pissed.
You know, Sarah, you can imagine somebody being in jail for 4.5 years. Their self-esteem, they're at the bottom.
Oh, I don't know if her self-esteem... Chad, do you think Sarah Boone's self-esteem is at the bottom? Or do you think Sarah Boone thinks she's the smartest person in the room? You tell me what you think. Is her self-esteem at the bottom?
Okay. And she's a fighter, as we all know. When she's backed into a corner, It's just her personality that comes out. She doesn't give up. She doesn't just say whatever. And it was her chance to say what she really believed based on her experience. And like I said, nobody knows what goes on behind closed doors. You know, we saw
Owens has parsed that very nicely. There are times where I will give him his due. He has parsed that very nicely and said, she has the personality she has. And so she's going to do what she's going to do. And he did say, she said how she felt. Didn't she though? Because I think what we saw from Sarah Boone in her statement to the court and God and country was exactly how she felt. It was exactly how she felt.
all videotapes of her berating Mr. Torres, and it appeared, you know, the state argued in the case in chief that it was a mutual abusive relationship. You know, we can only go with what we know and what's presented.
You can only go with what the evidence is.
The details and the extent of what went on. We heard Sarah try to explain it. I believe she was trying to explain it.
She tried.
Did she harm herself maybe by some of the things she said as it relates to Mr. Torres or his family? Maybe.
That's what she
I
thought.
was just going to ask you about that. Did you have an opportunity to go over Sarah's statement that she was going to make in court today, or she did this completely on her own?
Well, she had written that statement several days ago, but I was not able to get back down here. The holidays and some other things that went on until last night, so I had a chance to talk to her about that statement earlier, right before court. You know, I'm torn between being a lawyer and being a human being. I mean, she's facing life in prison. It's your chance to speak. You know, I don't like to take away everything, but I did have her delete a bunch.
She did say it was edited.
Owens is like, look, man, it's her chance to speak, but I was trying to help her help herself. Like, help me help you. Help me help you. And he's like, so I edited that out a bunch. What got edited out? But again, Sarah, I think, sat on the stand and told everyone how she feels. I mean, in a ranty journal entry style kind of a way with too many words sprinkled in, but that's for the psychologist to discuss. Because the grandiosity. But I'm not surprised that he tried to take some out and probably did before court go through with her and be like, no. Some thoughts are inside thoughts. But what we saw from Sarah Boone is that she's pissed. She's pissed and she feels like this was all an injustice to her. And she said repeatedly that George Torres made her do this, that George is the one to blame. That was really the gist of her statement, including the statement about the Scarlet Letter. So that's where she's at. I can't wait to hear the rest of what Owens has to say, which was, I told her to edit a bunch of it out.
In prison, it's your chance to speak.
Right.
You know, I don't like to take away everything, but I did have her delete a bunch.
She did say it was edited.
She did say it was edited.
Okay.
My suggestion, but to
It's
some
her
degree,
choice.
you know, she truly believes that she's a victim, and
she does.
You know, to
she
this
does believe
country, I'm sure there have been other victims of domestic violence that have been battered women that have gone to prison. There have been a few cases where they've been acquitted based on the testimony. but it's a case-by-case basis. It is a difficult syndrome to explain. It's a difficult syndrome to understand because most women leave. The first time some guy pushes,
Sir, you're not
strikes,
gonna
hits,
help
whatever the case may
yourself.
be, they won't stand for it.
A
But
lot
there
of
is a
people
small
don't
percentage of
leave
women
the
that
first time Owens.
put up with the abuse.
What's next for you now, Mr. Owens?
I'm going home.
So am I.
Yes.
He's like, I'm getting the
Thank
fuck
you.
out of
Thank
here.
you for your time.
Thank you.
Owens was like, get me out of here. Don't Owen. Y'all just Owens is not the domestic violence expert that we are going to. I also do not consider myself an expert in any way. I've just worked a lot of cases. What I will say though is that a lot of cases where you have a self-defense, whether that self-defense is categorized as battered spouse or not, a lot of states don't categorize it as such anymore. It is just a self-defense claim. A lot of cases where there is a very strong self-defense claim, those are the type you're going to see where people would get acquitted by a jury. They would look at the self-defense and be like, that's obviously self-defense. A lot of those never get filed. So it's difficult to talk about those cases as they go to trial, because when that self-defense is strong, they truly should never make it to trial, because that should all be handled either before filing or after filing. So it's a little bit different. And yes, for those of you asking, Jules was the one asking the questions, and she's with Trial TV Live, which is part of the Recovery Addict Network. Yes, there's a name for the network that I don't remember off the top of my head, but yes. So I'm going to see if he says anything else, and then we're going to keep going.
Scott, is there any
questions.
last questions you have? Do you have any questions for him?
Oh, Scott's on the phone.
Okay.
Top Mark Media, thank you. Thank you,
I
Chad.
think, this was a horrible accident that happened. I don't think she intended to kill him, but the state didn't have to prove that she intended to kill him. I do think she loved him, but it was a highly toxic, dysfunctional love affair that they should have never been together because of just the way he was and the way she was and how it ultimately ended.
It was that. It was definitely toxic.
Yeah, obviously, if you could go back in time and you'd want to change things, I think, they probably tried to break up 2 or 3 times. I think he moved in with his parents, and he would come back over. So it was one of those relationships. We've all seen him. We've had family or friends, maybe not this dysfunctional, but relationships where it's not working out, but they can't seem to let go.
The statement she made in the court with his family in there, knowing that he was
Thank you, Ohio Palm Mom.
alive, and the family there, I think her to say that she forgave them for not stopping the abuse. Is that something that you would
And we are on the camera of a different network that this interviewer's holding up a microphone for, so that's where the differentiation is between the audio here.
in that statement?
Well, that's something that she came up with that she wanted to say. And again, she's facing life in prison. I believe she was a victim of domestic violence based on everything that I've looked at in this case. So I know that she was a victim. Now, whether she was justified in somehow this happening, of course not. But
Well, she thinks she
Didn't
is.
that strike you as,
That's interesting. I'm going to back this up. Owen's statements are really interesting here because, again, their defense was going to that her actions were objectively reasonable, which means that her actions, they were trying to prove, I don't want to be taken out of context for that, they were trying to prove that her actions were objectively reasonable and therefore were justified as a defense. So it's interesting. I need to back up and hear what he says again, because he's starting to talk about it not being justified or justifiable. And so I want to hear what he has to say about that.
the abuse? Is that something that you advised her on in that statement?
Well, that's something that she came up with and she wanted to say. And again, she's facing life in prison. I believe she was a victim of domestic violence based on everything that I've looked at in this case. So I know that she was a victim. Now, whether she was justified in somehow this happening, of course not. But
I mean, didn't that strike you as
Interesting. So he's saying, was she justified in this happening? Of course not. It's I wonder if he's saying that because the jury found that she was not justified, but interesting.
did that not strike you as odd or not a good situation to be blaming the victim, the dead victim's family for?
The interviewer is saying, didn't it strike you as odd or maybe not a good situation to be blaming the victim and blaming the victim's family? And so I'm interested to hear what Owens' statement is to that. And I repeated her question just because it was a little bit low.
I don't know that she was blaming. I think she was saying she forgave him. She felt like they should have intervened. I know that sometimes you'll have.
Oh, Owens. Did you listen to her statement though?
Odd or not a good situation to be blaming the victim, the dead victim's family for?
I don't know that she was blaming. I think she was saying she forgave him. She felt like they should have intervened. I know that sometimes you'll have interventions where family members will intervene in a situation where you know it's so toxic or know it's potentially violent. You know the history of the person. I don't know. That's what she wanted to say. I believe she believed in her heart of hearts that she was a victim and maybe they should have done something sooner.
Right.
Maybe it is to some degree just Sarah Boone not wanting to accept the responsibility that she knew all along that she should have gotten out of the relationship. She just didn't have the courage to get out of it. You know, so she's wanting to say to other people, maybe y'all should have stepped in and helped me some more because I was too weak or not strong enough to, or not independent enough to let go.
What did she say after she was given the life sentence?
This is her asking, what did Sarah Boone say after the life sentence? Owens, okay, we're just gonna, okay. I'm just interested to see what the man keeps saying at this point.
I think she was, you know, she didn't say much other than, can you believe he gave me life? Or can you believe I got life? And I said, that's all she said. And then we started talking about.
And yes, for those of you saying, isn't that privileged? Yep. Unless she said, you can tell the media what I said and you can tell the media that I'm pissed too. Like, go and tell them all that I'm pissed. Like, you know, tell them all how angry I am. But otherwise, if she didn't give him approval, repeating what she said to him is not proper.
The appeal, and we started talking that she wants to talk to me tomorrow. I think I'm going to zoom in or something.
You're giving us
speak to her tomorrow about everything. So
all of your conversation with your
up there
client.
after that, you can't really talk to the client that much. And the only thing you can do is go down to the very bottom and talk to her. So I just told her I'd talk to her tomorrow. So we were talking.
He's
about
like, I want to go home. I'm not going down
form.
Stairs to talk to her.
Form for appeal. She wants me to file an appeal, and I'll do that within 30 days, and then the court will appoint an appellate lawyer.
Does she have grounds for an appeal?
I believe she's got, 4 or 5 issues. I'm not an appellate lawyer. I'm not a great, legal scholar, legal mind, but I know that I had a case years ago that I felt like there was some mistakes, and I know that I made sure we filed the appeal, and it was reversed on appeal. So I know it happens. And it was just my gut instinct that there were some things that were done. The appellate courts have a lot of power. They can find just one thing.
They can.
As being so egregious that it affects the entire trial.
I don't think we're going to see that here, though.
They can maybe find 4 or 5 things, and they say the cumulative effect, maybe.
Didn't the judge say, though, that there was no mistrial?
Yeah,
she said, didn't the judge say there was no mistrial? Yes, the judge said there was no grounds for a new trial. The judge denied the motions for mistrial. Judge K dotted the I's, crossed the T's, and said the bless yous throughout this trial. Unless there's stuff we don't know about. But I don't think there is stuff we don't know about, or Owens would be saying it because Owens is chatty. and he would have put it in his motions. So I don't think there's stuff we don't know about this case.
All the cases that have been reversed on appeal and had to go back and try it, the trial judges did the best they could and felt like there was no mistakes made.
So she's going to try and get another trial.
Of course she'll try to get another trial.
If when you file an appeal,
that's what you do,
and you claim that there was errors made either by the judge or by the prosecutor, or whatever the case may be, and the appellate court agrees and says we're going to send this back to the trial court. We're going to set aside the verdict, and it'll have to be tried again or resolved some way. At that point, it's back to square one for negotiations with the state attorney. But of course, that's her hope that she wins an appeal. Nobody wants to do life in prison.
Right.
Who will pay for all of this?
The state of Florida.
Taxpayer.
Sorry to be answering for. I realize I'm now answering for Owens. Who will pay for all of this? The state of Florida.
Ultimately.
But yes.
As in any case.
Yes, the taxpayers have to pay for her
I
appeal.
didn't charge anything to represent her, and all the costs and expenses.
That's how that works.
I'm not asking for reimbursement. So I agreed to take the case. Ms. Boone understood that. The court understood that. I wasn't going to be asking for any attorney's fees or any costs.
Why did you take the case?
Ooh,
that's a long story.
That's the question I wanted to hear. Why did you take the case? This is the part I want to know.
I've explained that before, but it was, if you remember, she went through about 7 or 8 lawyers, and finally the judge had deemed that she had forfeited her right to a trial, her right to representation. And so I think after that, of course, I'm a YouTube fan, so I was watching it on YouTube, and I saw a couple of hearings after that where she was representing herself.
I have to know where Owens was watching this on YouTube. Where, Owens? I'm a YouTube fan. What in the world? Have you also become friends with the pen pal, Owens? Oh boy. Oh boy.
And I can remember her saying something like, "Judge, this is not fair. I can't do this." So at that point, the court had ruled she'd forfeited her right to a lawyer. She couldn't represent herself. I didn't think somebody could get a fair trial for murder without a lawyer. So
he's not wrong about that, by the way.
I came up here and talked to her and agreed to take the case.
And now she'll get
I understand where he's coming from. I understand where he's coming from with this woman is not going to get the kind of trial that she deserves if she's representing herself. It's just not going to go well. Representing yourself is so incredibly difficult because you're not a lawyer. Sometimes it's really difficult for lawyers. So I'm not surprised that Owens is like, yeah, I didn't think she'd get a fair trial. But then going beyond that to say, I'm going to take this on at my own expense is really an interesting choice.
She'll get another appellate lawyer. She'll have an appellate lawyer that will, of course, everything will be typed up. Everything that was said, that's why it's so important to record everything. Everything will be typed up. And there will be a transcript, and that appellate lawyer will have to go through everything from the very beginning of the case.
But are you done at this point?
I'm done, other than I've got to file a notice.
He's like, I'm going home.
So I've got to do that. So I'm out of the case.
Thank you so much.
All right, very good.
Well, thanks for asking all the questions.
Appreciate it.
I mean, there we go. All right.
Yeah.
It was interesting to see what Owens had to say, and a lot of you in the chat are saying he said previously that he saw it on Vinnie Politan on Court TV. I'm not surprised that Owens is a YouTube fan. All right, let's as clearly Sarah Boone's pen pal is. I mean, today was wild. Let's do a quick summary. Oh, chat, I'm sorry. My ADHD is going to ADHD. I've got to give you guys the court break for just one moment because the robot vacuum has found its way close to my office and all I can hear right now is the robot vacuum. So give me just one moment to go to court break so I can send the robot vacuum back to its home so I don't have to hear it. Give me just a moment. Oh, I was muted. Emily, your mic. Let's get to a summary real quick, and then answer some questions, and then at 3 hours, blah blah, we will wrap up because I still have a podcast to record. So members, don't worry. We still have a podcast to record in a little bit. I don't know what time that's going to be. So I apologize. It might be incredibly late. So we'll just see what happens. And then we'll be back tomorrow, probably for a little bit of a shorter live stream tomorrow. Because we streamed today, and then it'll allow us to get ahead on the podcast for Wednesday and then for stream on Thursday. So let's do a bit of a sentencing summary. Well, the court did in fact sentence Sarah Boone to life, and because chat is bae, they reminded me, well, I guess it's not a reminder if I didn't know in the first place, but chat let me know that Florida in fact eliminated bail in 1983. So Sarah Boone or not bail, that's completely wrong. That Florida eliminated parole in 1983 so that defendants sentenced to life are just sentenced to life, period. So the options for the court today were in that 22-year range. The defense had asked for a downward departure into the 20-year range, and the court sentenced Sarah Boone to life. Yes, she had been offered a plea deal. Yes, the plea deal she was offered was for a lesser charge, the manslaughter, with a 15-year sentence, and she denied that. We saw the victim impact statements early on in the sentencing hearing from George Torres's mother, his sister, and his daughter. And then the defense presented evidence in their case, and that evidence included the chaplain from in custody who had worked with Sarah on Sarah's journey with God. We saw from her cellie, who said Sarah was always helping everybody, uplifting everybody, teaching everybody. And then we saw, or heard rather, from her pen pal who wanted to tell the internet a thing or two about Sarah Boone, and found this case and Sarah Boone about 11 months ago, and they became besties through phone calls, through emails, and through becoming friends over the internet because of this case, and took a moment to talk about how social media has gotten things wrong, how Sarah Boone is really a kind and generous person, and that she even offered her pen pal a kidney, and that the thing she was most upset about when she was convicted is that she wouldn't be able to give her pen pal a kidney. It was one of the strangest things I've ever seen happen at a sentencing. It's normally people who know the defendant prior to the crime. Occasionally, you see people who have known the defendants since the crime happened, but not as often. And then the defense called back the doctor that testified at trial to talk more about battered spouse syndrome. And then Sarah Boone took to the witness box to, she said, apologize. That's not really what that statement was. She, first of all, talked about kintsugi. I don't know if she's a Jelly Roll fan or not, but she was talking about the Japanese art of mending things that are broken with gold to make them stronger and to make them beautiful. Like we're all beautiful despite our flaws. And then she not so much asked for forgiveness as demanded forgiveness, and then blamed the victim, his family, the court, social media, the detectives, and everyone else. So it was wild. She at one point called social media a criminal organization. She talked about people having blood on their hands and on their keyboards, the media moguls who were exploiting her. It was a wild statement. It was not so much an apology to anyone, more of a, I have been misunderstood, no one knows the real me, and I shouldn't be here. That's my takeaway from Sarah Boone's statement to the court. It came across with a lot of rage, though at one part she did say, and in my soft-spoken conclusion, and I have to wonder if she was writing like stage notes to herself on her written statement to tell her that that was the tone that the conclusion was supposed to be in. It was wild. And then the attorneys both made arguments for the case. The state asked for life. The defense asked for a downward departure. And the court sentenced her to life, gave her credit for time served, and made no further statements about the case other than her advisement of appellate rights. I was really interested to see what the judge would have to say about the case, and he let it go. And that was it. So at the end of the day, Sarah Boone has been sentenced to life. A notice of appeal will be filed in about 30 days. There will be an appeal in this case. Appellate counsel will be appointed by the state, and away we go. So with that, let's get to your questions. I've got questions. You've got questions. We've got questions. Let's get to questions. Oh yeah, for those of you in the chat that are like, Julie said in the chat that Kintsugi sent me, same. And we actually had talked about it for all of those that were on the members only live before everyone, well, the media, the music industry got salty about it. We actually talked about Kintsugi and talked about Jelly Roll's Beautiful Broken Tour, because Brian and I had gone and seen Jelly Roll in concert last week. We had talked about this a bit. It was very interesting to me that she had a full theme of her statement. Like, her statement was themed, and she wrote her statement to the court saying, I am the broken thing. And all of these things that everyone else has done to me, those are my gold. So fucking wild. And for all of you that are new here, don't forget to get the Law Nerd app. I should mention, we can keep you in the loop with all the things that are going on with all the court coverage. Court's going to be busy this month. Well, at least in the beginning of this month. So if you don't want to miss a moment, lawnerdapp.com. We built it for you, so you never miss a moment. June asked if am I going to cover the Ashley Benefield sentencing tomorrow? No, I didn't cover the case, so I'm not going to cover just the sentencing, because I did not cover the case. So no, I will not. There are a couple other cases going on right now. I'm going to try to catch up on the cases that we've been following closely, because there's a lot of cases that we've been following closely. So with that, we're going to continue on with questions. Seba asked, will Brian get all he's asked from family court now? I don't know what Brian had asked for. And I mean, she's not going to have physical custody, obviously. I don't know what else he's asking for in the family law court, but there's not much that she can do. She can have some legal rights, but that's going to depend. Oh, hey, Trial TV Live, thank you so much. And of course, thank you for having a great feed. It's always appreciated. So we use, I appreciate having the interview of Owens, but used a different feed during the court proceedings just for the closed captioning, which is a hard balance, I know. So she wants alimony. He's still paying spousal support. I'll have to take a look at the family law case. I don't think he will be required to pay spousal support if she's in custody, but that is very much more a law and lumber question than an EDB question. I think that is a great question for Rob, because I don't think she needs spousal support when she's in prison, because her needs are covered. So that is a big part of it. Melanie, thank you for the super chat. Wanted to thank you for the Here Dears presents for no reason that came with my new hoodie. I didn't know that phrase, and you are welcome. I know that so many of you have loved the gift with purchase that came with your orders from the Law Nerd chat. Trial TV Live. No, I completely understand. It is not easy to do the closed captioning. I get it. Flutterby asked, will you cover the Jane? I have no idea what that trial is, and I don't know when it is, so I don't know. Rebecca said it's my 2-year Lawnard anniversary. Congratulations. Thank you for being here for 2 years. Nurse Theo said she's a case study in so many disciplines. Yes, it is a multidisciplinary evaluation of Sarah Boone. Megan said, thank you for covering this case. This case was an interesting one to come in as the jury on, because it was there was a lot going on in this case. It was a lot going on with this case. Mudrucker said, EDB, I got the gift with purchase and didn't even know I was going to get one. Amazed. Love the hoodie and the gifts. You are welcome. You are welcome. Kristen said, question, since he possibly is saying things that are privileged, could this make an appeal more likely? They're going to appeal no matter what. But things said after trial by the lawyer are unlikely to change the grounds for a potential new trial. Because I don't see how any of that could be a problem. Could Sarah try to make it a problem for Owens? Maybe, but there is also always the possibility that Sarah told Owens, tell them. So can his answers now hurt her appeal? No. Her appeal is solely based on the record in the trial and the judge's decisions in the trial. Kat said, thank you for covering the case. Of course, the rebuttal testimony was wild. So K-Rab, thank you so much for reminding me that it was Top Mark Media. Hazen said, do you think the judge was so angry he chose not to speak? It might just be this judge's practice to not say anything. And we've seen it used against judges, right? We saw it in the Murdaugh case. When the defense was making all of their motions, they absolutely came for what the judge said in their appeals and in their motions. So that was a lot of it. Totally thought your hats, God, not rock. I'm not mad either way. But yes, there is definitely an R on the Lawnard's rock hat. Stacy, there is on the Lawnard website a contact on the Lawnard website. Or on the Lawnard shop website. On the shop website specifically, there is a contact form, and if you go through that, they can help you. But that is where that would be, and everything was a little bit slower with responses because we were closed for Thanksgiving and the day after Thanksgiving. So we have the Lawnard shop has also been on a little bit of a Thanksgiving break, which was needed. Melanie, thank you. Won't this aggravate the judge? Probably. But the judge knows who Sarah Boone is, right? Like, the judge isn't surprised at this point. He knows. I don't think any of us are surprised by Sarah Boone after seeing the rebuttal case and the videos on the rebuttal case. Are any of us surprised? The thing I think that was most surprising to me in this entire case was watching her interactions with police, which were wild, and then the rebuttal videos. Those are the things that surprised me in this case. The absolutely surprised. Her just sidling up to the cops and being like, I can't get a hug, was fucking wild. Wild. Just wild. Becky said all of the Boone family court was set sealed. It was the multiple letters written to the judge that she wrote that are public now. Okay. Yeah, I was saying family law should be sealed. Nor said, I think the judge said nothing less to Sarah than giving her attention. He was like, okay, done with you. I mean, it kind of was a go to prison. Bye. Like that was it. Vampface said, my daughter lives in Buffalo and only got an inch. It depends which side of the city you're on. She's by the airport. My only knowledge of the Buffalo weather is from what I've seen on the TV when Dr. B is watching the footballs. That's about it. I don't watch a ton of football unless I'm there in person. It just, yay. Occasionally there's a good game at the end. But yeah, not always watching the football. What have I watched recently? Concerts. What else have I watched recently on TV? I watched the Martha Stewart docu-series situation. And Housewives. That's been about it. And every time I turn Housewives on, one of my kids comes down and is like, let me guess, they're all yelling at each other. Great. My kids have nothing. Carolyn said, did I miss her saying she was sorry and regretful? She was demanding forgiveness and then scolding everyone. Mm-hmm. 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 Oh. Mama Beth said she's talking about us. Here's some blood money. I don't think Sarah Boone has any idea who we are over in this little corner of the internet, but I'm not surprised she's mad. She's complained when I went back and looked at some of the hearings, she's complained about people covering her hearings since before I ever covered this case. So I guess it's not a docuseries. Is it a documentary? The one about Martha Stewart that's on Netflix. That's the last thing I watched. It was an interesting watch. I thought it was an interesting watch. So yes, I think it's on Netflix. That, and there's a Yacht Rock documentary that I will be watching. So those are the things on my radar. Stina said, Emily, would you ever let a client speak like this? I never worked as a defense attorney, so this is all in the abstract. But I kind of am along Owens' line on this is your chance to say what you want to say. And I would say be mindful of the judge listening. Be mindful that this can impact your case, and say what you need to say. That's really where I would be. It's their chance to talk. So that's where I would be. The ADHD Stitcher said, ma'am, you keep using the word forgive. I do not think that word thinks what you think it means. Also, you aren't God and you can't be blasphemed. Isn't it interesting how, and I think she used the word blaspheme more than once, that she referred to herself that way. And then her defense attorney is like, she has a very low opinion of herself. I'm like, really? Is that not what I've seen? That is not what I've seen. That is not what I've seen. But yes, I did catch that she was using the word blaspheme. Nash said, paralegal sitting at my desk listening through my earbuds and trying my best not to burst out laughing with your comments. Today was a full spectrum of emotion. However, full spectrum, just a full spectrum of emotion today. Oh yeah, the scarlet letter M. It was so fucking wild. Jackie O'Lantern said, this is the edited version. Right? I guess the question now is, will she start writing letters to the judge again? Being like, what are we doing? Neuro Sparkly said, the lion, the witch, and the audacity of this bitch. I mean, Sarah Boone's perception of her reality and the perception from this side is a bit different. And I don't doubt that she sees it. She doesn't see it as audacity. It just happens to factually be audacity. Sean said, lawyer, my very remorseful client would like to say a few words in her defense. Client, it is everyone else's fault. I'm perfect. How dare you think I'm guilty? Yes. And social media is a criminal organization, and you've all blasphemed me. That's what was happening. Vanessa Agatha all along is on my list, and so is Traders UK. I've got a few things on my list for over the holidays, because right now there's been like limited and discrete things I've watched because court's been busy, and going through all of some of the court filings just takes a while. So it's been a lot of reading court filings, truly. I'm very interested to be streaming 3 days a week next month. We're almost there, guys. We only have a few more episodes of the Wednesday podcast left, and then we are going to be streaming 3 days a week in the new year. I'm very excited. If you guys don't have the Lawnerd app, you're going to need the Lawnerd app to stay in the loop with everything that's going on this month and upcoming trials. Judge Cannone still hasn't ruled on whether or not the retrial is starting in January. So when you guys are like, what's the next trial? I don't know yet, because I don't know if Karen Reed is going to trial in January or not. So my scheduling is waiting on Judge Canoni's ruling on that motion to continue. Chrissy asked in the chat, EDB, how much impact does the impact statements actually have? Or is the judge already ready with their sentencing before it starts regardless? It really depends on the judge. I think a lot of the point of the impact statements is to allow the court system to hear from the victim's family, to allow the judge to hear it, to allow the defendant to hear it. And a lot of the sentences, with the way the sentencing laws work, are fairly prescribed. And so it's a balance. I don't know if there was much question about what the sentence was going to be in this case at all. Like, I don't really think there was much question. I don't think much would have changed it. I don't think there's much the defense could have done. This judge, I don't think, was inclined, after everything we saw in trial, to downward depart. I think the best option defendants have for a better sentencing is to let the judge know less about the shit that you did. The less the judge knows about the shit that you did, the better it's probably going to be. The more that the judge knows about the shit that you did, the worse it's probably going to get. So, do the impact statements help? Yes, in that they humanize the case. But do they change the sentencing? Not always, because judges aren't really persuaded by emotion with that. So that. Let's see. You guys, I saw somebody in the chat asking about the Judge Jumper case, the Redden case. The judge probably had looked at the sentence before and had a rough idea of what she was going to do. She's like, look, I decided this should be the sentence, and I'm not going to raise that because he attacked her. So that's what the judge said. But I've seen sentences go down when the judge is like, I think this is what's the right space. And now it can go down from there, but generally not up from there. It really, really, really depends on the judge and the circumstances. Laura M., it's like you're reading my mind. I have been thinking about covering the new Drake lawsuits. You know how much I like music lawsuits. So we will probably touch on it. We will probably touch on it at some point. Not tomorrow, but we will touch on it soon. So we will see. What else? There was one other thing I wanted to ask or wanted to answer. Chelsea said, Judge, I'm not inclined to acquiesce to your request. Totally fair. Totally fair. Colleen, this was a very fair point. Did she ever mention her son? No. She didn't apologize to her son. She didn't ask forgiveness for her son. No. She did not mention her son once. Not once. So, yeah, not once. Lexi said, yes, I've been trying not to beg you to cover the Drake lawsuits, but I need it. I mean, I'm not going to start singing Kendrick Lamar right now, but I mean, you know how much I love a music lawsuit. Do you guys, I'm going to put up a poll. Maybe we'll switch out topics for the podcast. Because y'all are like, we need something that's, not murder. So let me, I'm going to put up a poll. Drake lawsuits, yes, no. Let me know. I'm going to answer a few more questions and then we are going to go. You guys are like, yes, 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 yes. I mean, you guys are like, fuck yes, please. Marcel said, we just got our order. Thank you so much for the extra swag. I hope you guys love it. We'll talk about it a little bit more on a members only live stream about all of the things. So we will see. Aaron said, EDB, please do, because the Joe Budden podcast keeps saying they are petitions and not lawsuits. It's insane. Oh, it sounds like there's some clarification needed as well. I mean, we can do that. We can do that. This is a good question too. Megan said, why why credit for time served if it's life? At that point, it's really record keeping. So there's not really much of a benefit to it. In other cases there is, but it's mostly record keeping. So the other part of that would be, in the accurate record keeping, her case will be appealed. And if she ever gets a new trial, and if things change in the future, and if she is sentenced to something else in the future, then her credits are accurate and they're on the record. Or if the law changes, and this, we've seen this happen in other states. When the law changes, sometimes it does apply retroactively if it means you might now be eligible for parole, and that might happen down the road. So it keeps it keeps the record clean, and B, it allows for possibilities of what has happened. And I've seen the mod squad is like, yes, all the yes, the entire mod squad is like, fucking please, yes, yes, all of the yes, please, yes. Okay, music lawsuits. You guys are like, yes, yes, yeah, yes, 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 yes. All right. The law nerds and the mods have spoken. We will 100%. We will 100%. And we will shift. We will shift what I was going to cover Wednesday. It can wait. Cleopatra said, I thought Karen Reed was in January. Well, Karen Reed is scheduled for January, but there's a motion to continue till April from the defense and the prosecutor. That's still pending. So we don't know. You guys are like, yes, 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 yes. Okay, perfect. We'll just cover the Drake lawsuit. Great. We'll do that. We will do that. All of you are like, yes, yes, yes. Perfect. We'll do that. Perfect. We will cover it. Everybody's like, let's roll. Perfect. Tomorrow, though, we will be covering a little bit of Carrie Morrissey. It's going to be a little bit of a shorter stream, and we will get into the Drake stuff. So, and then we will circle back. PK said, what were you going to cover? Don't worry. We'll circle back. We'll circle back. I've got something in the hopper that has been in the hopper for a minute, but it's not super urgent. So it's just a case we've been needing to circle back on. But the chat has spoken, and this is much more timely. So everyone's like, no, I want to know about this now. And I get it. All right. Music lawsuit it is. Music lawsuit it is. Law nerds, you have spoken. I appreciate you. Yay. All right. And with that, law nerds, don't forget to get the Law Nerd app. Members in YouTube and in YouTube and in the app. I will be pinging you later. We will be recording a podcast. I don't know when I will be recording, probably after dinner. It will probably be late, but there will be a podcast recording this evening, probably late. And we will be streaming tomorrow. It's going to be a bit of a shorter stream after a longer stream today, but we'll talk about Carrie Morrissey's appeal. I need to do a little research because I don't even think we can do that. Anika said we need a case closed bumper. Not until the appeal's done on this one. Sorry, Anika. I know we're not done yet because it's a given appeal. And so we'll get there because we're still going to be covering this case because we're going to cover the appeal. I'm going to cover the appeal. I want to know. I want to know what happens. I know you guys are like, boo, no. We're ready to be done. We're done with Sarah Boone. We're done. But there's the appeal. So we'll do that. Law nerds, it's good to see you. Thank you for being here. Thank you for being in the chat. Thank you for being law nerds. You guys are the best. Mods, as always, thank you for the Monday ride. And you guys, I'll see you on stream tomorrow. So, bye. You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com or search the App Store for Law Nerd. You can also follow me around social media. And don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.